Madam, what do you want in that application, Mr. Chakraborty? That can wait, Mr. Chakraborty. I cannot take up. Extreme urgent matters, January, not before January. Sorry, Mr. Chakraborty. Not before January. This matter can wait, Mr. Madam, someone else is mentioning, please. Not now, sir. It has to wait. Yeah, I do not take up this way. Yes, madam. Monthly, sorry, madam. Mention in January. I'll take up in January. Not now. I can grant you leave to move the vacation bench. If you want. You want to leave? I'll grant you leave. Yes. Yes, yes. Ameda. Yes, caveat. But without caveat. This is when have you filed it? Listed. When was the order passed? Why waiting? When was the attachment order passed? Is it in the monthly list? Where is it appearing? দেখে নিও, দেখে আমাকে দিও, যদি মান্থলি লিস্ট হয় হবে না। ইয়েস, very well. Monthly list? So? Commercial cause? Commercial cause? Delay of? 150 days delay, just like that. Mr. Shah, yes. I can't take up. I can't. I'll give you leave to move vacation bench. Go move. I can't, sir. Argument, sir. You were sleeping. When was the order passed, sir? When? You do not know the date. Yes, sir. Yes, sorry. Yes, yeah, no. Move the vacation bench. Yes. You want to leave? I'll grant you the leave. No, I cannot accept it. It's not like this, sir. I'm not. There's no magic. The magic doesn't happen, sir. Please understand. If you have waited for so long, when was the order passed? You can't say. Yes, Mr. Shah. And responded the action what is the stage of the reference? The plaintiff is, the claimant is leading evidence. That is okay. Is it appearing in the monthly list, Mr. Shah? Why is the can there? This is the previous CO I had filed, where I have taken a preliminary point, arbitrator rejected the preliminary point. I filed the CO, the court honored, the court is pleased to and stay the arbitration proceeding.
This is not active.
Then take it back. No, restoration will not be taken. Has it appeared in the list? Where is that notice? Where is the notice? 53. No, very well. 50 item number 53. Write it down on a paper. Yes, hand it over 53. Very well. No caveat endorsement. Yes, madam. লিখে রাখো 53 টা so you don't mention madam. Yes madam.
File my
Item number. Why are you mentioning monthly list? Yes. No, sorry.
Application without any copy of the orders. The orders.
Monthly list matter.
No. New matters, praying for leave to file these matters. The orders are not even being uploaded. I applied for the certified copies.
By this court?
No. By the trial court.
Yes.
I filed 2 applications for withdrawal of the suit. They have been kept pending for more than 8 months. And the dates
in January, I'll get it done in January. I'll get it done. You mentioned, I remember this. You made it done, you mentioned it.
Yes. This certification is for restoration of CO. And the other
for
restoration of CO.
Don't mention.
Yes. Other side has the side of the miscellaneous case for enforcement of order for civil prison. That's why the next date is fixed on.
Let it be, sir. It will appear in usual court. No urgency. Yes.
There is a eviction should find in her.
Daily list, madam.
This is chapter 5.
Next month the list. Yes.
The matter. Number 88 of the daily list matter urgency here is the lower court below, that is third civil judge city civil court, has granted a status quo against the SRPC proceedings of the bank. I am appealing for the bank wherein the entire SRPC proceedings is done. My lord, if my lord gives me permission, I will not take my lord's 10 minutes time, more than 10 minutes. It's more than 6 months that learned trial court has not taken up my order 7 rule 11 hearing.
When was the matter filed, madam?
Matter was filed on 3rd of January. Even the matter was
January. This is a month.
December. I stand correct. 3rd of December.
For? When did you suffer an order?
We suffered an order. Order was passed in ex parte. That was in the month of January.
Sorry, madam. If you have waited too long, yes. Yes, you have to wait in January, madam. Sorry, not like this, madam. Not like this. You can't have so urgency. Matter of January, you come now.
What has suffered when we had been informed, when we appeared before the trial.
Sir, wait, madam. Come back in January. I'll take up your matter. Wait. Yes. It will be happy. It will be taken up, madam. Wait.
Just 5 minutes, madam. But the problem here is the Durgapur property, madam.
Which is your item?
Item number 88. Madam,
I'll grant you leave to move vacation means. Yes. Leave granted to move vacation means. I'll record an order for that. You mentioned I'll place it tomorrow. Yes. In that case, I'll record an order. I'll grant you leave to move vacation means. Do you want it?
What?
Yes.
7 September 2024 matter has been appeared but not in the list till now.
17 September.
24.
Yes.
But not listed.
Matter appeared in the list.
Appeared, not appeared in the list.
Monthly list. Next monthly list.
Wants to give evidence, and we have obtained the judgment.
And it's in which list? Which list? Monthly list? Next monthly list. I can't help you tomorrow. Not in the list. I know unlisted matters in this court, madam. Yes. And want a vacation means go view the vacation means in that case. Yes. Yes. Leave granted to move vacation means. Yes. What about order 7 rule 11, sir? What has happened anyway? And that is not the time to argue on this. Yes.
Order of cost against that order of cost.
statement not paid for the 3 years they have paid, the interest student will stay.
By
By an order of this code, 19 September, and before that was
vacation means signed in September. That will be extended automatically. You have to move vacation, Mr. You can file a vacating application, Mr. You see, sir, Mr. Ghosh, you move. No, your application for vacating is there. File a vacating. I'll take up in month of January. These will be expedited. You see, there are several. I had already by now taken up at least 50 to 60 matters from the monthly list, upgraded them. I have to, people have spent hours to mention, taken the pain. So unless I'm in a position to deliver that, no point taking up additional matters. You have to appreciate the situation. I'm trying to take up matters, but there are limitations. There are limitations. I'll take up your matter. Yes, sir. What do you want, sir? Father would be disconnected from the child's life ever after, sir. Sir, what is this going on, sir? Sir, please understand, you are not doing any charity by giving visitation. It is the father, is a right to visitation, sir. Father needs to know where the child, his blood. Sir, it is his blood. The mother needs to know where the child is. Please. Why are you averse to the father going and seeing where the child is?
Mother wants to interact with the child if the child.
Naturally, how old is the child? 7 years. For how long has he been detached with the father? Tell me how long has he been detached with the father? Tell me how long he has been detached. 1.5 years. Such tender age, he is detached with the father 1.5 years. Naturally, he will not feel like going to the father. You have to create an environment when he starts loving the father. Understand the situation, sir. Please understand, this situation will not continue ever after in your life. One day this child will grow up to be a major. Then you will be answerable, sir. No urgency in this matter. No urgency in this matter. Yes. January Didi. Provided there is no direction to go out of the list. Yes. Do not mention. I will not hear. I will not hear. Maybe, sir. I will not hear. That chance is gone. Yes, sir. Yes, madam. Any other? Yes. Sorry, sir. I can't. Maybe, sir. Last week, I allowed the mentioning. Do not do this, sir. Please do not disrupt the entire process, sir. Please do not. Yes. Can't help, sir. Yes. Yes. Monthly list I can't allow, madam.
But for inclusion,
yes. I have already allowed this, madam. Yes. No. Mentioning January, I'll again allow mentioning in January. Not now. Yes. Hand over, sir. All have allowed.
yes. Inclusion in the next monthly list.
Why? You have to withdraw. Then we mentioned why. Sir, I have to wait, sir. I can't help you now. Yes. Hand over. Yes. No, I have already granted. Sorry, sir. I have already leave vacation means.
Lordship, it is for inclusion, Lordship.
ওরম ভাবে তো লেওয়া যাবে না ওই কিভাবে হবে ফাইলের তো
Lordship, inclusion. Lordship,
মনে করে হ্যাঁ
Lordship, inclusion can be granted in vacation bench.
না লিস্টে যদি থাকে লিভ দিয়ে দিতে পারো তুমি লিভ দিলে ওগুলো ভ্যাকেশন বেঞ্চে চলে যাবে mention all these matters on Friday. You want leave for vacation bench, I'll grant you. I can't record an order like this. No, sir. Sorry, sir. Yes.
Lordship, it is for inclusion, Lordship.
Yes. Yes. That is all right, madam. The monthly list or daily list? Sorry, madam. Don't mention. Yes. Yes. Yes.
Lordship, matter is
Yes. Yes.
Lordship, matter is not even running in the list. It is for
Yes.
inclusion.
Hand over. Hand over.
Inclusion and Lordship, another matter, Lordship,
And
day
your
after
matter is
tomorrow.
already there in the list, madam. Why are you mentioning? Yes.
Lordship, day after tomorrow is the
Yes.
date, Lordship, for leave.
Against the next party decree, matters fixed for orders on 2nd of January.
Which list, sir?
This could be kept on the top of the monthly list on 2nd of January, my lord. Then
January you mentioned. I'll hear.
Expeditious,
yes.
expeditious disposal, my lord.
Not now. Yes.
Kindly include in the list, my lord.
Not there in the list.
Not in the list.
The other list. Yes. It was there in the list. Maybe he has been directed to go out. Sorry, sir. The other. Yes, sir. Do you need the 56? 53, yes. From the monthly list. Do not mention. Why are you mentioning? Now, if you mention further monthly list, I'll have to stop. You're wasting the time of the court, sir. I've allowed this last week. Yes. Which list, sir? Hand over. In the appellate side will be there in the monthly list. Clause 13 will be there. Clause 13 will be there in the appellate side. Yes. Yes, sir. Kindly wait. Do not disturb the process of the court. Someone is mentioning, sir. Yes. No, is it in the monthly list? Do not mention. Yes. Yes, Mr. Mukherjee. Yes, Mr. Mukherjee. Why will it go out of the without rejection? দেখে নাও যদি go out থাকে তাহলে দেবে না. Sir, you have been mentioning seeing, sir, kindly see, there is a procedure that is being followed by the court. Why are you interjecting when others are mentioning? You'll get an advantage. Why? The others are waiting. So many people are waiting. I'm taking one by one. Everyone is getting a chance. Why are you repeatedly mentioning Mr. Prasad? Yes, tell me what is your matter. Yes. Is it in the monthly list? Hand over the slip. It will appear in January. Yes. No, not now. 24, not now. 24, not now. Wait, which list? Police help allowed without hearing you. They will wait. You expect that they will wait. You will be, the other side will be dispossessed and thereafter police help. There is an injunction you are suffering. And police help. Why will you serve copy within 2 years? Within 2 years, tell me yes or no. Within 2 years or not? Execution within, when was the decree passed? Sorry, sir, nothing is there. Naturally, sir, nothing. Naturally, they'll put the decree into execution without serving you. Sir, law does not permit, please understand. Law permits service only when, please understand, sir. Sir, I cannot do that. You go and prefer before the appellate court, sir. Divisional court will not interfere. What is the jurisdictional error on the part of the trial court in directing execution of the decree without serving you a copy where no notice is required to be served? Show me the law here and now. Satisfied. See, here and now you satisfied. At a civil procedure, কোডোনাকে দাও. At a civil procedure, কোডোনাকে দাও. I'll come back to you. Yes. ওনাকে civil procedure করে দাও. You want a judgment from this court that should be treated as an application under 2197. Non, why 97? Why 97, sir? What is 208? Please understand. 208 is in yes. Sir, please understand. In an execution proceedings, there is no necessity to serve. No necessity. If you insist, I'll take up the matter. I'll dismiss with cause, sir. If you insist, I'll take up the matter. Please be on notice, sir. Please, sir, please be on notice. Not necessary, sir. In an execution application, sir, show me the law on the subject, sir, that you required to be served within 2 years. Yes. Sir, you go and obtain a stay. Have you been evicted? Thank your stars. Go and prefer an apply before the stay. So what can I do, sir? You ought to have gone earlier. When was the decree passed? When? As if you're saying, as if in December 4th, the decree has been passed. Don't say all this, sir. Yes. Sir, we have been on the other side as well, sir. Please understand the situation, sir. Yes. Sir, you take a chance. When was the order passed? Yes. When was it really filed? When did you file the revisional application? Yes. Which matter? I'll release the matter. Despite the fact that the court has indicated no mentioning, I'll release the matter. Give me. You do not want the court to take up the matter. So what can be done, sir? Sir, you ought to have mentioned the matter earlier, sir. Yes.
I am on the street. Evidence of that case. But in the pending forward case, while the matter has become the contentious, and ultimately, yes, my scope has become eliminated. So under this circumstances, I will make an application before the scope for the experience saying of my case. Matter is accepted.
Yes.
I consider my
No urgency, yes. Where is the application monthly list? When did you file it? You have mentioned, both of you have mentioned, yes.
Lordship, my matter
Yes,
is very
yes,
urgent,
madam.
Lordship, for leave, Lordship. Lordship, at least before the vacation bench, Lordship, because Lordship,
Yes,
5
I'll
years.
grant you leave before the vacation bench. Which item?
Lordship,
item?
it is yet to be filed. I have not filed for a leave.
Madam, I'm asked at the courage you have. You are yet to file an application. You mentioned the matter. Yes.
Lordship, for leave, I am praying for leave, Lordship.
He's waiting. Yes. Why?
But this is by one of the members of the erstwhile managing committee. He was ousted from the managing committee after a proper special general meeting. After that, he filed a suit challenging that decision, and he has taken order ex parte of debit fees. And not to tell you how. On the section 151 application, first filed in order 39, the trial court held that the suit is not maintainable. 2 days later, a fresh 151 application filed on the same cause of action, and an order passed ex parte for what reason we do not know.
Yeah. I was loath to take up. I was loath to take up since you are there.
All the operations of compulsion.
Sorry, if I can take up, if I
October, no, Lordship, we have filed an appeal. We have moved the appeal. The interim order is 5th of December. We filed the revision on. Well, that is not.
you are coming from the appellate order.
Lordship, we are coming from the order of the district judge, where the honorable district judge is trying to take evidence in the section order 19 application or a section 5 application in the appeal.
Move it during the vacation. Take it.
Of course, but Lordship kindly considers well.
In any event, this week I cannot take up. Please understand, Mr. Shortcut, this week I cannot take up. There are other applications which I need to take up first. These matters which I'm being taken up, I'll try to have them listed before the vacation. Only 2 days will be there. If it is possible, it is called on. Otherwise, yes. Sir. Last week I'm keeping it. Otherwise, he'll go to vacation. It's not possible to take up all the matters. You have to understand the situation. Yes. Because otherwise, what will happen to those matters which have already taken up? Please understand. Yes. Last week. Let's see, either Friday or last week. Either Friday, not before Friday. I have to exhaust the regular list first. Yes. That is different issue. For that, yes. Yes, sir. Accepted. Challenging that order you have come up. You have come up, challenging that order you have come up. Yes, I'll take it up. January. Mention in January. Oh, diye dao January. Yes. Still not completed. Where is Mr. Mitro? Before the vacation? It's not possible. Not possible. You see the list. You have to give the reply only after Mr. Mitro completes. Same, but you see now the situation changed a bit. The matter went on. Oh, he did not proceed. No, did you lead evidence? And Mr. Ghosh also says that revision will not be maintainable in terms of Section 8. So that point is also there. Very well. Don't mention today. Mr. Gupta, take a chance on, mention it on Friday. This matter only. So that I can fix it in that list. I'll not remember it now. Well, it can go to a supplementary list in January. January it has to appear in the list, and thereafter, or else do this. Let it appear in the January monthly list. But it will appear in the January monthly list. Then you mention it when Mr. Mitro is there. And then I will, after hearing him, I'll take him up. January monthly list. After it appears in the monthly, it cannot appear nowhere, from nowhere. You understand there's a system of this code. Because it has to appear in the list, either in the monthly list or supplementary list. Thereafter, I'll take it up. I remember your matter. But it did not proceed so far. I kept it on that date in the list so that you can mention. No, you did not mention before the other court. January দিয়ে দাও, এটা দিয়ে দেবে এই January দিয়ে দেবে month history. Thereafter you mention in January. Not now. Handover, not appearing in the list, handover. Yes, yes. Not appearing in the list. Handover, handover, handover. Near now, not appearing in the list, near now. Near January the year. I cannot take up. অ্যাপিয়ার করছে নিয়ে নাও মান্থলি লিস্টে দিয়ে দেবে কি অসুবিধা আছে হ্যান্ড ওভার আরে ওয়েট স্যার why are you so anxious sir why will I not hear you sir I might not accede to your prayer that is a different issue but I will hear you sir
Lordship, may I have your kind indulgence?
combined monthly psych Sir, I have never directed any matter to appear previously, sir. Sir, wait, let it appear in January, sir, I'll take it up. Mention it in January, yes. Can't help, sir, can't help, yes. Yes, sir, what happened to your matter? কেন আপনার অসুবিধে কি আছে মাকে নিয়ে যেতে আমি মডিফাই করে দেবো সামনের সপ্তাহে মাকে সমেত নিয়ে যান মেয়ে যেতে মেয়ে তো একটু বড় হয়েছে অসুবিধা হতে পারে মেয়ের Yes, intimate him. They will appear to be mentioned anything. I'm not saying পরে বলে দেবো এটাকে মনে করিয়ে দিও চেম্বার
And my lordship, keep the matter online on the day but that indicator is not in the list and matter is not.
Order is there.
Order was there.
Where is the order? Where is the order?
At the time of hearing, please to observe that the matter will.
Mention in January, I'll take it up. I remember. Mention in January, I'll take it up. Yes. Mention in January. You are sleeping so long, no urgency in the matter. Yes. In January, you mentioned. Sorry, sir. What were you doing? August? When did you mention last? Before this court? When did you mention before this court? Hand over. It will appear in January. Yes. Sorry, sir. Only one now. I can't help, sir. Yes.
My lord, this is two matters for early disposal, early hearing.
No, sir. No, sorry, sir.
Pending before the.
Sorry, sir. Early hearing, I am not allowed now. No, sir. I will not allow. Not the stage. Yes, yes, sir.
My lord, 30 seconds. 30 seconds.
Sir, not in mentioning on early disposal, sir.
Not mentioning, my lord.
Why will I? If everyone mentions for 30 seconds, matter will be over.
Designs, which is pending before the controller of designs for last 1.5 years.
Sir, mention in January. Make it effective. Why are you spending your time now? It will not be effective. I'll not take up now. You have to wait for January, sir. Please make it effective when mentioning. Mentioning January, I'll take up these matters. It is not possible for this court to take up early disposal of matters now. There are other matters which require a serious urgencies I need to take up. Yes.
Your lordship, may I conclude? But there's just one more matter, my lord.
No, sir. Don't have one only, sir. Yes.
Maybe to item number 66 is running the DD.
Yes.
The matter relating to expedition disposal.
No, expeditious disposal. Sorry, I will not take up now. No, sir. Sorry. Yes, Mr. Lakan.
Senior citizen, your lordship.
Maybe you have to wait in 15 January. No, sir. Sorry, sir. Yes.
Lord, I have let out my flat at a 50,000 rental, leave and license. My lord, the city civil judge has, my lord, refused my prayer for occupational charges because I have in my suit claimed eviction and mean profit. My lord, I am in need of money. There's been a demise in my family just 10 days ago. Though the impugned orders of September, this matter has been pending for 2 months. My lord,
Listed.
it's not appeared even once, my lord. But my lord, 10
January
days ago,
monthly list, you mention it in January.
Lord.
January monthly list, you mention in January.
grateful.
Yes.
If
একটা ফেরত দিয়ে দাও, একটা ফেরত
two
দিয়ে দাও,
revisional
একটা ফেরত দিয়ে দাও।
application, though it has been last heard on 12/6/2024 by learned Justice Bishwajit Bosu, and it has been directed by Mr. Basu that Justice Basu that the matter will be coming in the monthly list of July under the heading motion, but it has
Did not come.
It did not come. It has come in the monthly list till September. Then again from November.
Yes, monthly list matters I'm not here mentioning. Yes, why are you mentioning again, sir?
My lord, I'm paying apology, my lord.
What happened?
My lord, I'm paying apology, my lord, because right now I'm mentioning one matter.
Yes.
My lord asked me that he appearing in the monthly is not wrongly, my lord. I advise
Monthly list.
monthly list, my lord.
No,
But
no,
only one a prayer before your lordship. Only
Mention in January, sir. I'll take up all these matters. All these matters. Mention in January, I'll indicate. First day, I'll permit who, what. You see, so many matters taken up. I have to dispose of them. Otherwise, what is the use of mentioning?
only prayer before your lordship.
No.
If you go to the my lord, gone through the grounds
They
of,
mention in January.
grounds of the mentioning.
Mention in January. In January, sir. Yes. Yes.
Lordship,
So deed also,
Is it monthly list? Not now. Not now. Mention listed and mentioned
Lordship,
first
it
day.
has gone.
Yes, sir.
So, Aldar, you are aware this of the situation. What is? I have to hear you. There is no magic. Yes, yes.
To allow my mentioning,
Yeah.
because lordship was to direct your lordship's officer to give in the any day in the
No, I do not direct anyone. I don't direct. I retain the list of papers with me. Whichever is with me, those will be listed. I indicate when it appears. I'm very clear on that, sir.
You have to accept. You have to accept.
the suffering for the most
January you mentioned. I'll pick up at least.
any day in the my
দিয়ে দাও, monthly list দিয়ে দাও।
no, it is not this.
No, sorry, sir. Then.
Supplementary.
Sir.
Supplementary basis. My urgency is one.
Yeah, but
Now, when a London judge has debarred me to the law.
You are due to? Now.
Has debarred me to cross-examine the witness.
Cross.
Yes.
Without
but-
it.
Yes, but did not pass
When
any
is
order.
when is your matter?
Tomorrow.
Tomorrow it will be in the list. Tomorrow, কালকে তারিখ কত? Will be listed tomorrow. Yes.
I was very urgent motion, madam. Matter is,
Which list? Monthly list?
no, madam, this is not in the list. I want to affirm this.
Where is the papers? Where is the paper?
Affirmation, madam.
So you file it thereafter.
All I'm praying is inclusion in the list.
I do not allow expert. I do unlisted. I do not allow. Unless it is filed, I do not allow. Yes.
Lordship, all I'm praying is
You file it and come, sir. I do not allow. Please, there is a system I follow, sir. No, you file it. You file it. Normally, you file it. I will not granting any leave. Yes. Restoration is all in January. Handover, all in January. দিয়ে দাও, January.
Lordship, all I'm praying is
I'll hear you. January. Sir, wait for a while. Madam, anything else, madam?
Um,
Yes, these are January, yes. Yes, January, yes, all January. Handover, yes, yes.
My Lord, Lordship, the urgency in this matter is there was a
No,
determination.
no, just a minute. Please,
I'm sorry. I'm sorry.
Of the special manager. Yes.
No question. Huh?
Turn down. Decided once. I'll be here it. Oh, expertise be granted in January. And I can figure though.
May I have?
Lordship,
Lordship, this is a matter where the determination of outstanding
Sum it
rent
up,
was
teacher.
made, the entire amount was paid.
The
The
determination.
determination of outstanding rent was made, the entire amount with interest was paid.
7-2.
Lordship, subsequently, there was another determination by the same court saying that further interest needs to be paid without calculating the amount which I have paid, including the amount I have paid towards interest. Now the court says we are going to strike off your defense if you don't pay the amount. Lordship, the matter is fixed for 18th of this month. Lordship will kindly take up this matter. Lordship, on the face of it,
I'll grant you leave if anything happens to move the vacation bench. It's not possible. I'll not possible to take up. You have to understand the situation because these are additional mentionings. Apart from this, there's a bunch. And you see, every day I've upgraded. Today also there are several upgraded matters.
very good.
If only I take up upgraded matters, then what will happen? The list will go for a toss. You see,
Lordship, this is not in the list. This
file it. Leave to file.
Lordship,
No, Lordship, it's been filed, but it's not yet come in the list.
Let it come.
Filed in September.
Let it come. September.
We have already taken adjournment twice in the court.
File in September,
Yes,
Mr. Kaur. You're not so serious. You leave for vacation bench. If you wanted, you come back.
I had mentioned it
It
before.
will be endorsed on the. It has to be endorsed, perhaps. If I grant leave for vacation bench.
Yes,
He has not yet. He has not yet. In January, you mentioned. I'll take it up. Since there is a threat of your
threat is that
7-3 order being passed. And monetary aspect, you paid without prejudice to your rights.
the entire amount has been paid by us once. After the husband has died, the widow has become the tenant. And now the widow has been asked to pay the entire amount all over again. Entire amount, we have the receipt of the rent controller recording.
Then there is an appeal from that, perhaps. That will be an appealable order, will it not be?
Perhaps, because it's a reopening of an issue which has already been decided.
Yes.
The amount was decided, we have paid.
Anyway, come back in January, mention it. It will be an interesting one. If it is otherwise maintainable, I'll take it up. Otherwise maintainable, I'll take it up. That you check up in the meantime. Since he is reopening, 7-2 orders are not appealable. But
It's not. And the entire issue, once decided, it could
then
not.
come back in January. It's an interesting one. I'll hear you, Mr. Kaur. Yes, sir.
The predicament is the matter was this combined then before vacation it was appeared before the justice standard. My lord, there are a bunch of matters were thereafter, my lord, it has not been reached. Thereafter, they have told that matter was released and it has sent back to the department. Unless it has been mentioned, it will be not released.
January month.
Lordship, my only problem is the matter is out of the list. I am just praying for inclusion in the monthly list of January.
Yes, January, provided no order is there for directing it to go out. Yes.
May I have your lordship leave to mention a stay
Much
application? It is a group 2 HON'BLE matter. On that
Group 2.
Group 2.
Group 2, determination I don't have. Yes.
In application, the file is lying in
Group 2, determination I know don't have. Only 227, madam.
The compelling circumstances are mentioning this matter. Applicant is a senior citizen and his owner.
You mentioned it. I refused it. Yes, sir. Sorry, sir. I refused it. You have to wait. Yes, sir.
19th June. 19th June 2024. Filed the
19 February.
Fine.
June. Yes.
That-
It is in the monthly list.
The matter for passing an order.
So I have to wait. Yes, sorry. Monthly list matters I'm not permitting. Yes, sir. We have to wait, sir. Yes. Not mentioned. Coming January, because reason is this. I don't want to deny it for the sake of denying, sir. Bunch of matters are there. Already have taken. Unless I'm in a position to dispose of them, it'll be a shame. You see, the persons have taken, the advocates, learned advocates, is in such pain to mention those matters. If despite their mentioning and being able to succeed in the mentioning is not listed, getting an order or no order is a different issue. Difficulty is, sir, today, I understand the situation. You file a writ petition and you pray before the court and you allow my, at least hear it once. This should not be the situation, sir. Should not be the situation. You are entitled to be heard at least once. Entitled to be heard. Thereafter, if no order is passed, it's a different issue. You come to court, you file it, and what do you say to the client? We do not know, I am filing it, what will happen? So, sir, I am trying to take up the monthly list matters. We are today in March, April. I am taking up presently the April matters. I started off with January. I am in April now. Expected I'll reach in another month or so, June. And so I'll try to regularize it to the extent permissible, sir. And there will be always urgent matters.
Not allowed by.
Come back in January. January I'll allow again, once again, urgent matters.
That unfortunate luggage of mine, Lordship. Your Lordship allowing my mentioning on 18th November, fixing the matter on 9th December. But 9th December, the matter has not been mentioned as 9th December, the matter is.
In the order sheet, it was not mentioned.
Lordship, your Lordship and allow.
দেখে নিও order কাগজ দেখে
Item number 963 of combined list, Lordship.
চেক করে নিও, যদি অর্ডারে না থাকে তাহলে তোমরা দাওনি কেন দেখে নিও। ইয়েস
8 তারিখ মেসেজ করতে লিখে দেবো কি দাদা, লিখে দেবো।
In 2001, my last suit for declaration of tenancy right was filed. I am the landlord. Another matter. But anything in the supplementary list in the January, in the month of January.
January I'll allow in the list. You watch the list, I'll allow for everyone. I'll take it up to my limit. I will be taking up what is permissible for me. Yes, call the list now.
Lordship, may I Lordship list? Your Lordship, may I?
January. Can't help, sir. When was the impute order passed? When was it passed? No, when was it passed? Yes, who is appearing for item number 1?
My lord.
My lord, I am appearing for the petitioner.
Spite of notice, nobody have mentioned the right. I'm for the respondent. Nobody have mentioned the right.
No, this is the heading under the heading returnable motion on 16th. এটা returnable motion এখানে to be mentioned কেন? এটা এখানে কেন? Oh, acha, one. Yes. Yes, who is for the petitioner?
Lordship, I am for the petitioner. I am led by Mr.
And who are you, sir? In the matter?
I'm for the respondent matter.
Yeah, and what are you saying?
I'm going to file a vacating application.
Vacating of what?
Order.
Which order?
4506.
Lordship, this is something else.
4506.
Give him notice for mentioning but is not mentioning.
Lordship, this is some
In
other.
this matter, you are there.
The CEO.
This is CEO matter. He's
Item number 1.
Kindly check up, sir. Different matter. Yes.
no, item number 1 I am.
Yes.
So I think I'm mistaken.
The ESIC.
Lordship, I am for the petitioner. I am led by Mr. Shoma Mujumdar. He's
Yes. What are you seeking? What is the prayer?
Lordship, the prayer. Then shall I start? Then Lordship, I am actually
You
praying.
wanted special invitation?
No, Lordship.
Send to your residence that you will start or not, sir? Yes, tell me. What is your prayer?
Lordship, I am only praying for read in the Lordship, there is garnishee proceeding order under section 45G.
These are annexure P1.
Yes, I'll
So-
fix it for hearing. Mr. Mojumdar is not there. He'll find it difficult.
Lordship is coming in just 2 minutes.
No,
I
it's
think,
here.
cash, mainly, Lordship, the issue is that, yes, your Lordship, the main issue is that cash trade.
Who are you, sir? Wait, sir. Yes.
My lord, actually what has happened, my lord, a 45A order was been passed.
Tomorrow.
That your Lordship.
Tomorrow, under the heading returnable motion. Mr.
Lordship,
Mujumdar,
he-
to be mentioned, it is appearing to be mentioned.
My
today.
Lord, Lordship, is
Tomorrow, returnable motion.
Very short point,
I know, I remember. Yeah, tomorrow, returnable motion. Come back, I mean, returnable motion. It will be, it's little down after the motions. After the motions. Get ready for hearing on the matter, finally. Nothing really remains in this matter.
Item number 2.
You see, question is whether you could attach a cash credit account or not. Settle law, come and show me, I'll hear you. Attach other things, so many things are there, who stops you?
And not for the real person, by me.
Hey,
That's a different.
hey,
That is a different issue. Not
A real person is.
hey, এই মামলা কি হলো?
Because the PAN
Liste
card
আসেনি?
also has been issued, my lord.
To be mentioned? কি to be mentioned নেই?
For the petition. Or I am the owner of a premises, a 17B. I am a owner of a premises, a 17B Tarak Datta Road. It is a two-story building. I am residing as a owner in the ground floor, tenant in the first floor. Tenant is occupying 4 rooms, 3 barandas, 2 baths and kitchen. He used to pay 970 rupees as rent earlier. Now, at the present moment, no, the tenant. I am the landlord. Now, there is no landlord-tenant relationship. I am the owner. Now, I am against a trespasser. His lordship knows that section 2G of the West Bengal Premises Tenancy Act provides. I am on this way, so the defendant has no defense at all. He has no defense at all. Kindly see 2G. Urgency is I succeeded in the suit. I got the degree. I want to enjoy my degree. That decree was challenged in Order 9, Rule 13. That application for condonation was dismissed. He preferred revision and withdraw the revisional application, then file appeal. Now, you will also can see the order of Justice Vishwajit Basu, Honorable Justice Vishwajit Basu. His lordship held that against an order of condonation of delay, no appeal lies under Order 43(1)(c). So this appeal cannot be maintainable. appeal has to be dismissed. Kindly see 43. And kindly see the order, then your lordship only comes to the appeal has to be dismissed. Kindly see, my lord, first order. First order, page 34A, page 34A. I think my lord is seeing page 34A. Kindly comes to the last part. I am not reading the entire page. Page 39, capital A. Kindly see. Original order at page 18. Page 18. I have got the certificate copy also. I can hand over to your lordship. No, certificate copy of the appeal court order I filed. Both, sir. Page 18. I have brought. I am filing here. Yes. Now, I am both the orders I am filing. Kindly, page 34, capital A. Certificate copy of the first order. Certificate copy of the first order, the ex parte decree. This is the first order. That is page 34A. I am showing it also. Page 34A. Relevant portion I am knowing. 34 certificate copy will be necessary. It will be necessary. I am not. No, I have not preferred appeal against this order. No, he preferred appeal. I have not preferred appeal. I have not preferred appeal. Kindly see, he can. Then I have given the certificate copy. No, he preferred appeal. He has to file before his lordship other side. No, I am not challenging. I am accepting this order. Order 9, Rule 13. Order 9, Rule 13, I am accepting. Merger. Appeal revision has been filed thereafter. Revision was filed before the Honorable High Court thereafter. Then appeal filed. Appeal. Yes.
This arises out of any correction leave and order indicating an application of section 5.
Yes.
That certificate copy was also required to get.
Also required.
Justice Bhaskar already passed the judgment of this. Already there is a judgment of this court. That was the standard practice that was being followed.
The other side also can help the court also.
See, on the last day when it came up, Justice Vasu, this same proposition that it was raised by Justice Vasu, and Justice Vasu was directed, has been pleased to direct to file certificate. No, not written direction, but it was observed. It is verbal.
I filed 2 certificate copies. That is the order passed by the court. First order and last order. I filed the certificate copy. No, that I have not got. No, no. Kindly see, then I have given the no, I have given the type copy. This is not.
No, there is no direction, Lordship. There is no direction. Or the verbal observation was there by the Honorable Justice Basu.
I filed the 2 certified copies. Kindly see the merit of the case. Merit of the case. If you lordship if you lordship contend that I have to file the certified copy. No, I have given the type copy.
হ্যাঁ তো কি হয়েছে জিজ্ঞেস করতে পারো বলছি তুমি আগে নেওয়া হয়েছে তারপর তুমি কেন আর্জেন্সি দেখিয়েছো তুমি আগে তো মামলাটা হচ্ছে তাহলে কেন আর্জেন্সি দেখানো
Kindly see the Follow, this is a suit. This is a suit.
Proceeding with
Kindly
not sub the copy.
This is a wrong statement. My suit against a trespasser. Kindly see section 2G. Then he lordship, he has no defense.
You are saying that no appeal that you are trying to say, you are trying to say no appeal could have been filed as an order indicating damage.
Yes.
Yes. I will consider your pre-certified case. This is in January on a particular date.
ঠিক আছে
সার্টিফিকেট কপি আনতে পারবেন সার্টিফিকেট কপি আনতে পারবেন কতদিনের মধ্যে আনতে পারবেন
জানুয়ারিতে রাখছি জানুয়ারিতে রাখছি
Kindly fix at the top, my lord. No, kindly. Today is item number 2 after 5 times mentioning. Kindly fix it. Order dated 10th of August 2023.
10th August 2023, CC number 126 of it. On the ground of visitation. By the annexation right of and the name of Visitation of the order of the 6 and challenge.
Page 85. Page 85.
All of the delivered by the same setting. On 19th February 2020, I will take all the subject the
Now, today I have
বলেছে আগে স্পিক দেওয়া
I have not been placed. I have not been placed. In view thereof, let us understand that one. And here, the department of graduate
Lordship, third week I'm not available. There is a marriage in my family. Third week I'm not available. There is a marriage in my family.
Before 13 January, kindly consider this. This is the long time, your lordship. In order to in January, first week of second week of January. Kindly see only one point. My lord, I argue only one point. My lord, I will argue only one point. Kindly fix it first week of January.
Oh, 6 February.
Huh?
6 February. 6th February. ঠিক আছে।
Six.
Okay.
Arnotsi.
Lord, I am appearing for the petition. This is my lord, my affidavit of service. The wife is with the my lord, the urgency is my lord. Now this 6th January has been fixed for peremptory hearing already. Evidence has also been taken by the husband. The main matter is my lord, with regard to maintenance pending lighting. And my lord, the maintenance has not been allowed in view of the fact that the wife is getting maintenance from the criminal court in miscellaneous cases, which amounts to 8,000. And my lord, today, my lord, the husband's, according to husband's income, I am entitled to. My lord, the entire suit is to be disposed of in the meantime. Then, my lord, I will not. My lord, the pending litigation. My lord, but in the meantime, if my lord, 9,000, but I 40,000. And my lord, if I do not, my lord, 1/5 is not the formula. I have a child, my lord, his education. My lord, there is no formula itself, but according to the needs of the family, my lord, this is required to be given, my lord. The husband is getting 40,000. No doubt, my lord, there I have not disputed that he is getting more. He has the court has considered he has a parents. My lord, the parent is a businessman. He has a cloth store. My lord, 13,000, that is the deduction is with regard to road. That is, my lord, so far as that is concerned, I have no. Kindly, my lord, I have also annexed his salary pay sheet. Kindly look into at page 30. Wherefrom I am getting 9,000. No, not at all. 9,000, and my lord, the 33,000 has been allowed to area maintenance because he could not pay. There is two 9,000 in total out of the 8, and 1,000 from the maintenance.
My lord, kindly look into that where he has stated to liquidate area he is giving 3,000. My lord, whatever my lord, kindly look into 8,000 I have given. There is a my lord, kindly consider it, my lord. Otherwise, my lord, the suit shall be proceeded and my lord, I am getting my lord 8,000 and my lord 3,000. 8 in total 8 plus 1. 9,000 I am getting and my lord 3,000 has been allowed to be area maintenance. My lord, therefore, my lord, kindly consider it, my lord, that unless the suit, my lord, in the meantime, my lord, kindly stay the suit, my lord. My lord, stay for the time being. Suit. The suit. The my lord, hearing of the suit should be stayed. My lord, here, my lord, there are judgments also that unless the payment is made, my lord, that suit should be stayed. My lord, there are areas to the extent 2,01,000. My lord, that too has not been paid. My lord, that case also application has been made before the court. That too has not been disposed of and court is allowing, my lord. My lord, the separate application has been made before the court. The order has not been passed. My lord, so far as that application, but no, that is not the challenge. Therefore, my lord, even my lord,
Item number 4.
My lord, item number 4, my lord, the father is the petitioner with your lordship. My lord, application for interim visitation right of the father has been disallowed by the learned trial judge. My lord, our prayer was during the vacation, winter vacation, the father wants the child to be in exclusive company of the. My lord, your lordship, can you first comes to the application, my lord, page 195. Nothing, my lord. I will just tell you, lordship, a suit differences existed between the party. But now, my lord, no, nothing. My lord, what the learned trial judge says, I want my son to be with the father, the grandparent. Son, my lord, his son, age, my lord, now less than 6, my lord, he was born in 2000.
He will turn 6 in January.
6 in January, my lord. Therefore, my lord, I want, my lord, this is initially an order of the learned trial judge giving me a liberty to see the child. The wife disobeyed. Against that, my lord, we came before this honorable court. Honorable court give just a shortcut, my lord. I'm showing the lordship's order, my lord. Lordship directed to produce the child. She did not come. Now, my lord, during the vacation, your lordship. My lord, during the vacation, the father wants the child to be with him. He wants to take him during the vacation. Not custody, my lord, this interim visitation. My lord, I see your lordship. No, interim visitation, my lord. Visitation, my lord, he wants to take it to New Delhi to see his grandparents. My lord, you will also kindly consider. Mother, my lord, mother will not go because mother has. My lord, I tell you, lordship, my lord, desertion, my lord, he deserted the matrimonial home at Delhi and took the child when he's 1.5 years old. My lord, your lordship kindly considers. Now, my lord, your lordship, I am a natural guardian, my lord. I've got a right to spend time with my son. If your lordship allows me, lord, I'll come to Calcutta, my lord, for 5 days. My lord, from the last 22, my lord, I'm running the pillar to post to see my child in spite of the order of the trial court and the high court, my lord, I could not go. Well, overnight, my lord, this child should. The bonding is there, my lord. In the video call, my lord, the father and the child meets, my lord. Therefore, they are very. Yeah, as your lordship, my lordship, what your lordship will say, my lord, my client will do. I am grateful, my lord.
Item number 5.
But so far as this case is concerned, my lord, already I have served also, my lord. No, I have served copy, my lord. There was a direction for service. I have already served out of both of them, my lord, to the learned advocate as well as. There was an order, my lord. From the DB Act and also, my lord, that facts I have stated in my applications also. And my lord, that too court has not taken into consideration. The court has taken it that I am entitled to maintenance only to that extent which I have been given. Because of the child's expenses, he has also stated uttered that since I am a graduate, I am entitled to art. My lord, in fire service. West Bengal Fire Service. The 42,000 salary, my lord, out of which I am, my lord, starving with a child, my lord. The child is, my lord, the expenses I have also given. That too court has not taken into consideration properly. I will have to expenses for admission. I have to explain. In a kindergarten school, my lord, the English medium, the 3,000 annual, my lord, session fee, 22,000. All these I have given. Kindly look into page 64, 63 to 66. No, first man. Yes. We come to the order sheet. What?
petition. But I have already taken an inspection. Where from it appears, suit was filed in 2018. Allegation of the non-payment of arrear rent. Subsequently, my father was the original tenant at that relevant time, appeared and also filed an application for 7.1 and 7.2. My father died in 2002. From the inspection, I have an information slip. It appears, kindly. I have already applied for certificate copy. Along with I take the information. But the date is fixed in the 21st. Kindly give a limited stay. But otherwise, my petition will be infructuous. My defense was struck out. I have already applied for certificate copy.
12 December.
Not 12 December, we have applied. I have tried there. Kindly give some indication that in the meantime, give some relief. But we have so far the kindly so consider. But yes, yes, yes. 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 But that's my. So, but 21, kindly consider. Already defense was strike out and matter is fixed for hearing. That's why the urgency I have mentioned it. Kindly consider. So, 21 to 22 year losses, otherwise 20. That is a COVID. Well, I will pay again. This is not second. This is the first time. Kindly consider. My father died in 2021 in the COVID period. Some grace period for COVID period. After death of my father, I have substituted in 2023. During that period, I could not. Even when they have to determine my knowledge transfer. What is lying with the court itself?
For that time, there is witness. So in the meantime,
then the result, the decision will be taken abide by the result of the rules application. Otherwise, they will not consider, it will be expertly heard out.
Order number 6, appear for the petition. The petition is the plaintiff in the court below, my lord, suit for declaration injunction, my lord. During pendency of the suit, my lord, the defendant forcefully entered into the plaintiff's property and installed permanent iron pillars, for which I have filed an application. No. CO 3794 of 2024.
ভুল করেছি
I understand. We are also.
Item number 7.
Lord, sir, I beg to appear on behalf of the petition in this matter. Lord, sir. I have mentioned showing the urgency on the ground that
ঠিক আছে আমি থাকছি 4টে 4:30 অব্দি চলে আসবে আমি আপনাকে সকল প্রেসটা করে দিই
My lord, I beg to appear on behalf of the respondent in item number 7, my lord.
Lord, sir, I beg to appear on behalf of the petitioner, Lordship, in this matter.
Yes.
Your Lordship, I have mentioned the matter stating the ground the bank in exercise of their right under the Surface Act has taken physical possession of the property. And
What
we
is
have
the
the
urgency?
the urgency is that, Your Lordship, the bank has taken physical possession. Initially, an interim order was passed by the learned tribunal, subsequently extended by an order of the learned tribunal below from time to time. Extended every time. Thereafter, the opposite party made a proposal before the tribunal below. He intended to settle the matter. In view of that matter, learned tribunal did not pass any order for extension of the interim order. Since the interim order has lost its force because of non-extension of the same by the learned tribunal below, the learned since the order of district magistrate order was passed, taking physical possession of the secured 31st of on 1st of February 2020. Thereafter, what happened? The learned tribunal below, the interim order which has lost its force,
He reimposed it.
he reimposed it.
He's not. He's incompetent to do that.
No, but the only difficulty is that, well, actually, the only difficulty is that taking
Sir,
an
please
advantage.
understand. Please understand the situation. Come before the High Court or any court, and you a matter. You get an interim order. There is no application for vacating of matter content for whatever reason. So once it is extended, technically it can be extended, but it can be reimposed.
But cannot be retrospective effect. From the date of passing of order, position is not but with retrospective effect, if anything happened, the bank has taken physical position, taking advantage.
That will remain state.
The only
I'll
difficulty.
clarify the situation. I'll clarify the situation even better. Now, in that case, if you have taken position, you will not disturb the position.
What they have done, the opposite party filed an application for restoration. Since the bank has violated the interim order, kindly restored the same at interlocutory stage.
Order has been restored.
No.
What do you want?
My only difficulty, Lordship, my only submission before your Lordship is that I am judgment passed by the Honorable Apex, where the Honorable Apex Court has held if the interim order from time to time extending by the courts, and if subsequently it has not been extended,
it is not here. How will I deal with the matter?
But so I believe the other side I have already served.
You serve and come.
I have already served.
Before the revisional application or direction.
Kindly state the operation.
Why will I stay the operation of the restoration of the order? Why will I, sir?
Lordship, may I?
Why? Please tell me a good reason why.
Lordship,
sir, you may be in a situation. It was a settlement that has to occur.
No.
Where is the order? Where is the order improved?
Lordship, the order improved, first of all, your Lordship, the
which page?
Lordship, the last, the certified copy I have annexed.
Yes, okay.
Certified copy of both the code below.
Naturally, you have to do that.
Yes. So, Lordship, first of all, your Lordship, I will, since the order, interim order was extended, I have preferred an appeal before the Honorable DRT Kolkata. DRT Kolkata, by the impugned order, has dismissed the appeal with certain observations. I have placed the authorities of the Honorable Apex Court, whereby the Honorable Apex Court in unequivocal
appeal court has affirmed the order.
Yes, of the tribunal below. Of the tribunal below.
What remains in the matter? Now,
I preferred an appeal before.
This is not an appeal. What irregularity did the tribunal commit?
Lordship, that is...
No, first appellate authority, what irregularity did it commit?
Lordship, the first appellate authority has committed an error.
Error will not do, sir. Error will not do. I cannot correct an error of law.
Lordship, Lordship, kindly appreciate the situation, your Lordship.
You show me there has been a material irregularity committed by the learned judge. Factual aspects I cannot go into.
So certainly.
You can show me that the learned judge did not hear you, or law does not permit such a course of action to be taken.
Lordship, this is my cause of action. The law does not permit him.
Lordship, kindly see the order impugned. Passed by the appellate tribunal.
Serve.
Lordship, copy has been served, Your Lordship. Already been served. They are caveator, I have already served them. I have already served. Affidavit of service with me, Your Lordship.
I'm not prima facie satisfied with the case.
Lordship,
but
prima facie, kindly allow me to place my case with certain authorities.
challenging the dismissal of an appeal. Stone, you can succeed in your matter.
Bank is in
that it cannot be, if you have done something irregular during the pendency of an interim order, if that has happened, because the order records that you just simply filed one vacating application.
No, Lordship, no. That is why, Lordship, kindly.
No, on the next occasion, when they come, I will hear you.
Lordship, the only difficulty is why I have mentioned the matter.
It cannot be reversed. It will be so irreparable.
No, yes, so irreparable. Why, Lordship?
Have you sold the matter? I sold the property.
No, we have not sold. We are in physical possession. They are asking for restoration.
Yes, let us see.
This is our difficulty. They are facing the tribunal.
Let us see.
Kindly clarify the bank will be in possession.
If the tribunal restores the position, and if the parent order goes in the meantime, then status quo would be reversed. This court is competent to pass
That's a 10 crore due outstanding
for protecting your interest.
Lordship, kindly, subject to your Lordship approval, obviously, because I'm.
Serve and come, sir.
Yes, I sell. Only I'm predicament subject to your Lordship approval. Obviously, what I'm trying to convince before your Lordship is that 2014 NP, whatever order that is binding upon me, I'm not. I'm trying to convince your Lordship.
Without serving, I will not pass an order, sir.
Lordship, may I? Subject to your Lordship approval. Only 1 minute. 2014 NPA, two surface application filed challenging the surface action dismissed.
When the order was passed in the year 2019,
Lordship.
the stay order, what were you doing then?
Lordship, they have the interim order.
No, what were you doing? Interim order 2019 when it
We
was
have filed opposition. We have opposed the
Did you
interim order.
challenge the order?
Lordship, from time to time it was extended.
So did you challenge it? You allowed the interim order to be extended time to time?
We have filed opposition. We are ready to argue, but the interim application filed one after another.
Sir, let us see what happens in the matter.
Lordship, kindly
Don't say it is so irreparable. 2014 NPA and everything has gone. The court did not consider anything. Don't come up with such a big case. But your case I will consider when they come. Other side comes, not.
Lordship, DM order
Yes, call the
has
next
not
matter.
challenged. This is the difficulty.
May it please your lordship. The plaintiff before your lordship. Yes, yes.
David is there.
Yes, they are on
Should
caveat.
be after the vacation.
No, it possibly cannot wait.
With the stay, with the injunction then. He's here.
No, the injunction is
Here.
already there.
Other side is not there. So there is no injunction. He's here. So it should go with the injunction.
No, but the injunction is there against which we have come up. My lord,
Yes, yes. The
My lord,
injunction
the
is
revision.
challenging.
Yes, my
What
lord,
is the plain case?
yes. My lord, the plaintiff claims right in respect of a portion.
Julian Day School.
Julian Day School is is the petitioner before your lordship, the defendant before the learned trial court.
What is the scope of the, what is the, in the prayer?
But would your lordship kindly give me a minute, my lord?
Yes,
May I in a
Yes.
nutshell, my lord, indicate?
Yes, yes.
No, nutshell indicate. No.
5 minutes.
No.
5 minutes. Now, before the vacation, you see,
But
otherwise.
this
I'm
possibly
interested-
cannot wait. Otherwise, we would not have troubled your lordship.
That's why you make it immediately. They come up with the, what is the plain case?
Yes, the plain case is, my lord, declaration and injunction restraining my client, the defendant, from, my lord, encroaching upon a property. This is the plain case. The plaintiff had purchased the property by under a surfacey sale. There's a deed of conveyance in their favor.
Conveyance also execute.
There's a conveyance in their favor. Conveyance specifically says that they are in that deemed possession is being given, and they shall not claim possession. And I shall show the clauses. We have been in possession since 1969, and this portion, this is a plot of land which is being used by the school students for their prayer, for some regular sports activities as a playground, and for disbursement of the students post the school hours. When
Injunction
the
has been granted.
injunction has been granted, restraining us to
By the.
trial court refuse the ad interim order, they come up before the lower appellate court. The lower appellate court, my lord, grants an ad interim ex parte injunction without a single line of reasons. We come up in revision. The revisional court sets aside that and remands the matter back for, my lord.
Final hearing.
Yes, the
Before
appeal
the
has been
trial
finally, no. The before the appeal court. We have come up against the final order allowing the appeal, and
Injunction application is pending.
injunction application is pending. We have not been served with that. Recently, we have been served.
Contested, Mr. Gupta.
No, because they had not served the injunction application because it was from an ad interim refusal. So we have contested the appeal by filing a written objection
It is.
in the appeal.
You ought to have contested the injunction. You have ought to have said, kindly send it directly to the trial court.
But the Honorable High Court, while disposing of the revision, directed the lower appellate court.
You did not prefer that, sir. High Court will only allow whatever prayer was made before the court, sir.
No, but the
It was
appeal,
your revisional application.
it was my revisional application, but the order was from the
Order was being set aside.
the order was set aside, directing the appellate court to hear out the appeal within a particular period of time.
Miscellaneous appeal. Where is the order? You ought to have insisted, go an injunction application, let it be disposed of.
26.
Today, what can be done? Suffered an order.
Ad interim order. Judge suggestion appeal.
Where is that order?
186, my lord. The first round of revision, my lord. 186.
No, no. Yes, yes, fine. Arey Baba. It runs into pages.
My lord, may I draw your lordship's attention, my lord, straight away to, my lord, paragraph 22.
It
is at page 201.
Stage. Everything at the interim stage.
Yes.
Today we are still at the interim stage.
Today we are still at the interim stage.
And the appeal has to, the injunction application has to be heard.
Has to
There
be
is no finality unless you say, both of you say that you give up the injunction application.
No, I do not want to. That I do not want to. But the problem is in such, during such time.
Difficulty, Mr. Gupta, today.
But the difficulty today,
I
before
cannot
what?
set aside this
But
order.
before your
and send it
lordship
back.
apply your lordship's man, only one fact, yes. I should appraise your lordship. But on the strength of this order, what they are doing is now they are going before the court, before the police authorities, and with the help of the police, they are barricading by permanent construction and preventing my ingress.
You are
The
using
students,
that.
I've been using from 1969. They have recently purchased. And may I show two clauses from the deed? But they are permanently ousting the students, and it's not something where we are making any construction. The students use the playground. These are the pictures where the students have been there for the prayers. This is the portion which the land
They
trusts.
don't want it there.
I'm sorry, Malad.
They don't want it there. Please understand their case. Let me find out.
But they have taken a
Let
risk.
me find out.
But they have taken a risk by
Wait.
purchasing.
That is different. That is different. That is different. Let us go. Matter has to be. That's what I'm saying. How long will you fight on a interim order? After all, the injunction application has to be heard. Now, no finality is attached to any of this, unless you say that there is.
How can I say 39(1)(2) is pending?
Yes, sir. Practically, they have been dispossessed by the interim order.
What in
We are saying that what is the urgency? It was mentioned. Let us understand that. Sports is there on that date. Prayer or no prayer, that is different. It appears to be open field. Yes. Prime facing.
Surrounded by.
Very well. Very well. Very well. A school is there, but had been running for.
There. Oh, this is the.
Adjoining the school.
It's not the school.
Just.
School is somewhere else.
Adjacent.
Adjacent.
No, property descriptions are different. And
Here, I will direct this here. I will, if you are not accepting the proposition, the matter has to be heard out. That is a different issue altogether. If you are accepting the proposition, consider it. It may not. The school says sports for the sports meet, it is required. And that is the ground for urgency. I have taken up this matter. Why I have taken up this matter? Sports may be fixed in a few days.
Not sports. Playground for the children and prayer.
Every day.
Every day. Every day playground, prayer, and for disbursal of the student.
No, you said that winter sports was there also.
No, playground. No. For the playground and for the sports, regular sports, not a winter.
For the sports, Mr. Gupta, I can do this. Please hear me. Injunction application has to be heard, to my understanding.
I bow down.
I find that matter has been fought like anything, but at the end of the day, does not really matter.
At the interim.
No finality attached in any.
Yes.
You file your written objection.
I shall.
Within a month, or maybe a month, will be taxing the learned judge. Well, human being, you see. Within 3 months, let the learned judge decide the matter. You will be entitled to, in the meantime, sports, if they have, permit them for the sports. Permit them for the sports, not for regular prayer. No, not for regular. No, Mr. This, if you are not interested, then I'll hear out the matter. I'm not saying that I'm not trying to impose something on you, Mr. Gupta. Please.
Sports day, they will apply to us. I am here around.
Yes. And maybe Mr. You see, at the end of the day, you are aware, sir. Has to make an alternative arrangement also. If the school has to make an alternative. For that, some time has to be given to the school. It cannot happen overnight. They were so long using and utilizing it. Maybe you will be denying and disputing the same. I cannot go into these issues in the revisional application. Neither can you impress upon me, nor can he, because everything was in appellate stage, miscellaneous appeal.
All are in private.
There is no opposition filed by them as of today.
In the appellate court, they are filed.
That will not be taken into
account. At private stage, interpretation stage, it can be filed. Before the appellate stage, contested hearing after filing.
Only limited extent. Mr. Gupta, take instructions. If you require, I'll send it back. 3 months, it will be decided. In the meantime, weekly sports, you will apply.
Only one thing.
Listen to me. Weekly sports, you will apply, and they will give you that permission. Without creating Equity, simple as that. Please understand, matter has to be hard. Matter has to be hard. Today an injunction order has been passed, full-fledged injunction order has been passed. Today to dislodge the aforesaid interim order, you know it will not be easy. And on the first date, I cannot.
No, I shall show
Then I'll place
it's
it.
explicitly perverse.
No, no.
Because what they
Then I have
couldn't
to
get
place
by their deed, they are getting indirectly.
I'll set aside this order.
They are getting
I
indirectly
will
by
set
this.
aside this order, send it back. Subject to what Mr. Basu says. Because this matter has to be heard.
What my lord has proposed, me as a council,
Take instructions. You're replying. Take instructions from your client and come back. Tomorrow. Take instructions, come back tomorrow. Or take instructions here and now. School, after all, at the end of the day. A school matter, you will be every week, sir. Weekly sports you have. You do the weekly sports.
Also, my lord, it's the. My lord, I have, my lord, your lordship will kindly hear me for.
And after that,
two
if you suffer
sentences.
the injunction with after 3 months, effectively,
My
he's
lord,
getting 3 months.
only two sentences, my lord.
Yes.
My lord, their deed specifically say they will not have possession, they will not claim possession. A. B. I have a permanent.
Then you are asking the court to permanently decide this issue, which cannot be decided.
No, I am saying at the ad interim stage, this document or these clauses have not been considered. So this order impugned is perverse. My lord, we should be sent back. My lord, may I only indicate one thing? Kindly permit me. Kindly do not take me away.
Set it aside.
Kindly, my lord, I am saying that kindly sets this aside. Kindly indicates that during such period we shall be it's only the students.
Can you argue in the
My
matter?
lord, they are not really, my lord, they are not
Can
really
you argue
doing
the
anything.
matter?
No construction, nothing. Only prayer. For 10 minutes they will go in.
But once you argue the matter, then it is on merit, whichever way it goes. Nobody is saying that you are not ready. You're saying, sir, who is?
No, I'm saying on the prima facie case, I will ready.
My lord,
What their case?
yes, I shall.
Wait, sir. Mr. Gupta is there. He's having a tough time here as it is because he has, you see, at the end of the day, he may have a very good case. But difficulty for him is miscellaneous appeal, he has suffered it on contest. So to dislodge that, I have to hear both of you.
In any event, you have
Today, I cannot stay the order. Mr. Motion cannot be done. This will remain at least for 3 months here. For 3 months here in the contest.
What fell from your lordship, we'll bow down.
No.
Well, we'll bow down
easier
only
for you.
I understand. Only one addition. May I indicate?
Yes.
Only one addition. My lord, the prayer and the guardian's disbursal. My lord, that is the place where it.
Guardians
And this
dispersal,
will
they
not-
lose the position.
My lord, no. And
They're not in
but they are
not in position.
my lord, they are creating what they
Failure.
did not have. This is the ploy. The deed says they will never claim possession. The deed never says they will never claim possession. But what I was humbly praying.
I will not.
But what I was I will go back.
I will not go into any of.
I will go back.
Because
Kindly.
you have not used opposition.
Yes. My lord, kindly, my lord, permits us to use that will not create any equity. We shall not claim any equity.
Certainly that
on
will
the
not create any equity.
Yes. On within 2 months or 3 months,
Be the
whenever.
suggested order.
But this will your lordship will pass. But your lordship will.
They will agree.
No, now, ask him.
Immediately, my lord, lordship.
Then tomorrow.
But this is what my lord observation. I will.
Additionally, he wants the dispersal, which is not permissible under any circumstances. That cannot be permissible.
I cannot allow.
Yes.
But the prayers will. But they are not in.
Weekly. Every week. You go every week. You go there every week. Ask for sports. I'll record that. Permission shall not be with it. I'll record in my order. No permission is necessary. I'll record in my order that weekly they will be entitled or any day, one particular day, and you will not raise any objection.
Could I come back in the second half, my lord?
Yes.
Because every day we are facing this problem. Police complaints are being made.
And it will not be made against the school, sir. I understand this.
But there is a 144.
Mr. Vasu also understands.
There is a 144. My lord, there is. My lord,
Please
they are
understand.
going with full animosity. My lord, they are not treating this as a school.
Mr.
There is.
Vasu,
They have taken the risk. My lord, it's
Please
genuine.
understand. Even if you have to throw him out, please understand. If you have to throw him out. Correct. So he has to have some time.
Not to enter in my possession.
He has to give him some time if he has been using it. I do not know.
My application, what it stands is to prevent them not to enter.
They don't have protection. I shall show
But,
you.
to record my presence, Lord, I have a leader, but to record my presence, may I say just one thing?
Yes, yes.
This is a sale under the Securitization Act. And the bank.
I've heard that. I'm not going into that issue. After all, Mr. Court, after all, a school is saying that you are interfering with my rights. Whether the school
That right he has not been able to establish. That is the finding of not a single document.
Today hearing has not taken place. There is no hearing.
No, before the appeal court.
Appellate court only. Because
appellate court, they have not produced a single document. Not a single document.
If you even travel to the Supreme Court, but still then at the end of the day, the injunction application is not heard. So there is no finality attached.
Let the injunction application be heard. There is no difficulty. But Lord,
that is their deed. Jene shune bish koreche pan. They have taken.
We'll read the deed together. We'll read the deed together. We'll read the deed together.
Finally, sees two clauses.
This will go on forever.
Whatever my lord's observation is there, I will take instruction.
Yes, and weekly they will be doing it. Saturday, yes. No, I will provide in the order that will not object. Not object. No. School, after all, school can't go and beg. School cannot go and beg. If he's injuncted, and matter is finished. But he cannot beg. Principal cannot beg. Please understand.
Anybody.
No. After all, the principal is in charge. You know how it works.
Anybody can.
I'll provide for in the order. Every Saturday or whichever day you tell me.
But one day, this.
Naturally, one day. You said sports on that, yes.
Yes,
one day, every Saturday, they will be using and utilizing it without hearing any.
I've taken instruction. We cannot,
Then
we'll have to.
your matter.
But we have to, because it's not Saturday. There is no school also, and
Friday.
But it's not a particular event
like this in here.
May I try and satisfy your lordship?
Very well.
May I try?
Very well. Challenging. Then I'll place it to the interim order. I can't grant.
No, they are creating.
That has to be heard.
They are then kindly injunct them from creating. But kindly passes an order of status quo as on.
No.
Not because they are they are constructing a boundary wall now. It's not that. I have photographs to show. I have photographs to show that they have engaged men and masons to construct a boundary wall to permanently block the students.
To some extent, they have damaged. Repairing it.
No, there is no question of damage. I shall show. But possibly my learned senior friend is not properly instructed.
No,
which order are you challenging here?
Yes, your lordship will kindly have a look at the impugned order.
12th November 24.
Page 256, 257.
Yes, impugned order.
It's an order dated 12th November.
The original order is 22nd of March 2024.
That is the ad interim refusal.
Naturally.
By the learned trial court. They go up in first appeal, miscellaneous appeal, before the lower appellate.
And that was finally decided.
That was finally decided. That is the order impugned, my lord. Your lordship will kindly have a look at the impugned order.
Challenging the order dated 22nd of March 2024.
But could I show two clauses?
Finally, I'll hear you. I'll place it for hearing.
But then your lord, this will spill over till after the vacations.
Yes. Yeah, I cannot do it now. You are aware, Mr. Gupta. It's not possible.
But I'll tell you. Your lordship will kindly give me a moment. But they are initiating police complaints to forcibly throw the students out. They are taking out 144.
You've got an order of
that is why that
is under challenge.
This is a matter
I
which
cannot
possibly
vacate that order. Mr. Gupta, please understand, without a hearing on this, and this matter will require hearing.
Could I only suggest something in the meantime?
Yes.
Subject to my lord's kind consideration. But would your lordship kindly permit the user, and it will not create any equity?
I will permit the user of a sports stay, provided you give up your right here and go back to your trial court. Only on this consideration. You can't, sir, you can't have two things at the end of the day. Please understand, you are fighting a litigation where the application is yet to be decided.
But I am coming up with an order which is especially perverse.
No, you come
which I can try
from a refusal. You have come up from a refusal to grant an ex parte ad interim order. Miscellaneous appeal, they had come up. And in that, an order was passed in their favor finally, granting that.
On contest.
You ought to have insisted, send it back. When you succeeded before
the order of
No, you ought to have insisted, send it back. What will I do there? It has to be before the first court. There is no finality attached even to this order.
I understand.
Because this order is finally
But
the matter
taking
has to be sent
advantage
back.
of the subsisting
Sent
injunction, they
back.
will create the construction and try and
With this
create a
order, you
situation.
want with the order, I will send it back with the order. But you do not want that. I had given a better thing, but you are not ready and willing to accept that.
The better thing which your lordship is proposing
know,
is, my lord, the only one day of
There
the
is
week.
nothing. There
is
is
only
nothing
one
now.
day of the week.
Because there is nothing now. You will be utilizing it. There is nothing now. So far as there is nothing now.
Yes, but my lord, the prayers is for 10 minutes. It's every day for 10 minutes. But they shouldn't be they shouldn't be wanting the pound of flesh in respect of these matters.
You said that you said. You
No,
said
I
that
am
you don't
using.
drop. See,
Yes, I am.
What you said is.
Because I have been there in from 1969.
Gupta, what you said that parents disbursal.
Yes.
Prayers.
Yes. And regular.
You say it is not the pound of flesh, but it attracts also a lot of blood along with it. You remember? Not a drop of blood.
Yes, not a drop of blood. Yes.
So therefore,
but what they're
it is
getting,
not that easy.
what they're getting is not fortified by their deed. They have the deed says they will not claim possession.
The court of competent jurisdiction
The court of competent jurisdiction has not
decided
considered
this,
those clauses.
Has decided this, wrongly decided this, wrongly.
Yes.
Wrongly. To set it aside, I have to apply my mind, hear you.
That is why I'm
I have
saying
to hear him.
in
It is
the
not possible before the vacation. It is not possible, practically possible before the vacation. It is not possible, Mr. Gupta. Please understand the situation. I'll fix it after the vacation. In month
There's
of
winter vacation also in the school.
kindly keeps it sometime in the first week of
not
January.
possible. February, it has to go to February.
But then kindly passes an order of status quo till such time. But they will not carry out any construction. Well, otherwise, my hands will be cut for all times to come. They are carrying out constructions, engaging men and masons. They are constructing boundary wall to cordon it off. Your lordship not interfering at this stage will my lord, cut my hands for all times to come. So my lord kindly protects me to that
This is
extent.
not
I
your
should come.
suit.
This is not my suit.
This is not your suit.
want to get something in
Neither did you file any application in their suit.
No.
You did not. You are trying to resist an order in their favor. Please understand.
Yes.
You did not apply by filing a suit that you are trying to interfere with my rights. It is not your case, Mr. Gupta. Please understand. So that the court can grant you that protection in their favor. No, not beyond status quo. Because today, if that is done, the suit will be rendered infructuous. There is nothing for you to be decided.
I bow down.
What is to be decided is whether they have interest or not and protect my interest. So court has protected their interest. Yes.
But all I want, let the injunction order as it is remain there.
No, cannot.
They should not construct the boundary wall.
A lot of you ought to file a suit. You did not chose not to file a suit.
What I'm humbly submitting is they should not construct a boundary wall.
You are a fence. You are sitting on the fence and you are trying to say, do not do this. Do not do that.
I was not only sitting, I was there inside the fence.
But now you are outside the fence.
Yes.
I say, do not do this.
But
please do not do this work because you are not entitled to possession. I am entitled. If you are so conscious that you have a possessory right over the property, what prevented you from applying?
But I understand.
Then you understand.
But I understand. All I seek today is because your lordship is posting it for some other.
Made by me at this stage.
No, because
I also tie my hands for on the future date to pass any order in your favor also.
I'm
because if you insist for an interim order today,
all I seek no construction of boundary wall.
If you seek an interim order, then I have to refuse the interim order by reasons. If the moment I do so, I will be recording certain things which will be creating difficulty.
Because your lordship is posting it sometime in next year. That is why if
because vacation is there.
But if
you want a clean slate or not? What do you want, Mr. Gupta?
Well, I only want your lordship will hear the matter, but they should not construct in the meantime.
No, I cannot without hearing that. Because you have not applied for anything. I would have understood there is a suit filed by you also.
But I can also go before the trial court. But they should not construct in the
apply and then come back. Then I'll consider your consideration. There is no scope to consider that issue now. Where is the scope to consider? Where is your application? Where is your application? Please understand, Mr. Gupta, please understand. I'm only trying to, while discussing, while making myself heard, I'm only trying to consider in a suit filed by the plaintiff for declaration for injunction, whether you are entitled to seek protection.
I am not wanting any
Your
other
protection,
protection.
you are
No,
seeking.
Your Lordship will kindly appreciate one thing. Possibly. What I want today is no further step for construction.
Very well.
The injunction, let it remain.
Very well.
I am saying because your Lordship is posting or remanding, whichever way, let
No,
them
I'm
not construct.
remanding it today. I'll hear you.
Let them not only thing
Where is
because
your plain prayers, Mr.
yes, my lord, I'll indicate. My lord, your Lordship will kindly have a look at page 147. 147 is the plain prayers.
133 is the prayer.
No, 133 plain. Prayer 147.
And what is your right, Mr. Gupta?
Yes, my lord, before that, the plaintiff has to prove his case
what
and
is
not
your
rely
right?
on the weakness of the defendant.
What is your
Kindly
right?
see page 71. Kindly see page 71 bottom. I shall trouble your Lordship with only 3 clauses, nothing else. Page 71 bottom.
The declaration defendant illegally attended.
Kindly see J.
Public injunction.
May I read it? The authorized officer of the secured creditor vendor and further authorized officer of the secured creditor vendor has handed over deemed possession of the secured assets. That is 1. Kindly turns over to the next page.
Do you claim adversarial interest in this property?
Yes, and I have a document to show I have a perpetual tenancy.
Where is your written statement? Where is your written statement?
No, I have not been served with the plaint. We have not been served with the summons.
There
They
is
have
no-
gone up with the ad interim refusal.
Where is your case of adversarial position made out in
Yes,
the
I shall show.
Let me
I shall show just 2 clauses before that.
Yes.
Not I shall show.
That's why this.
Not I shall show. Kindly see page 72. Only 1 clause.
Yes.
Only 1 clause.
No, clause will not do. Your case made out.
My lord,
Clause will not do.
he has to survive or fall by this plaint. If he can't prove his case, then possibly, my lord,
Where is your clause? Where is your
I
clause?
shall show. Kindly see one clause. I will not trouble your Lordship with any other clause. Only 3 lines.
Sitting outside.
They have cause of action.
Title is not perfect. So don't grant him any injunction.
Yes.
Can you say that?
Yes. Possibly, yes. Kindly see page 73. Why I say so?
No right.
The deed
has a
says
weaker
they will
right.
not claim possession. They have
no
got
right.
something.
He has a weaker right. Please
But
understand.
I have a document to show that the person from whom he had got the property, or rather the defaulting borrower and his
Your case that you are in adverse position, show me that.
I have made out in only 1 clause. I shall show.
Nothing
Very,
more.
very good. Kindly seize my written objection. 175. 75. My lord, paragraph 6 at page 176. Then, my lord, paragraph J onwards at page 179.
Where is your case that you have been holding out against the
Yes,
owners?
J at page 179.
Yes.
Paragraph J.
You run a
kindly seize-
school.
I run a school, then K. The erstwhile owners of the said property had granted an irrevocable license in favor of the respondent and
You
or the
claim
said-
under them. You claim under them. You are not adverse in position. You are not claiming adverse position.
No.
So I asked you.
I have a so possession is with me, title is with them. What they are doing is they are ousting my possession, which they did not get by the deed. The title can be with them. I'm not
Where is the
challenging their
license?
title. I'm not putting
Where
up
is
a
the
false
license?
case.
Where is the license?
Yes, your Lordship will kindly have a look at page 297, 247. 247. It's an agreement for tenancy.
This was not before the trial court.
No, not before the trial court. But logically look it, I will make this case clear.
No, this
So
was
that
not before the trial court.
No,
logically look into it, because I will.
appeal court recorded that they have not produced any document.
Before the trial court, nothing will be there.
No, before the lower
No,
appellate.
I mean appeal court. These documents were not there before the appeal.
I see.
It was not there before the
First time before this court.
It
Yes,
was
in 227.
My lord, you kindly look into it.
first time
Kindly
before.
look it. I demonstrate my case.
Unregistered, registered agreement.
Unregistered.
Unregistered.
Tenancy agreement.
Tenancy.
The date. Because your lordship kindly mark the date.
Yes.
2016.
Yes.
That's all.
Claim was irrevocable license in the objection.
I shall place the clauses. Kindly see page 249.
Yes.
But kindly sees B. The tenant is seized and possessed of, otherwise well sufficiently entitled to, as the full and absolute owner of all that Elgin Road. This is my school. Then kindly sees, my lord, C, the next page, 250. The said premises, 35E Elgin Road and number 4 Umananda Road, Kolkata, where from the activities of Julian Day School is being operated, is contiguous and adjacent to premises number 3/1 HM Road.
Yes.
Then D, in view of the shortage of space in accommodating the students and their garden, and also for providing ample space for students to have for having lunch and or tiffin, the said tenant has been looking for a suitable area in or around the adjacent premises owned by them for sake of convenience. And the owners herein, with the intent of constructing a multi-story building in such and such area of such and such, more or less hereby refer to said premises with the aim of commercial exploitation, duly applied for and obtained a building construction plan. That is neither here nor there. Then kindly sees, my lord, H. Under the said right, a tenancy purely on compassionate consideration of extending the support to the beneficial social purposes being held and used by the tenant on the terms and conditions mentioned hereinafter. Then kindly sees page 251. Kindly sees clause 2. It is specifically agreed that the demised premises shall be held and used thereof by the tenant strictly for the objects and purpose of the tenant and or for beneficial use and utilized thereof by Julian Day School run and managed by such and such. The tenant has deposited a token as 11,000 as token security deposit and 11 rupees per month. Then kindly sees clause 7, clause 6. 9, sufficient protection is there that I shall not be able to sublease or sublet or assign.
10
and 10. But this agreement does not is not a time bound agreement. There is no time fix for this. Kindly see the rent. It's 11 rupees on compassionate ground. Now kindly sees page 73. Kindly sees page 73.
Yes.
Clause 3 at page 73. The undersigned, being the authorized officer of secured creditor, hereby declares will be transferred in favor of Vendi as on as is where is and as is what is basis whatever there is, and is such the purchaser shall not claim any right of occupancy possessory in respect of the said secured assets more fully described in the schedule. So I have a better possessory right. I have not claimed adverse possession because that would be dishonesty. I cannot claim title. But what they are doing is,
how can you claim?
I am not claiming.
You are a tenant, you say.
Exactly. So it's not a case which the defendant has sought to run at all. The only case which the defendant has sought to run is I have been given right of user for a particular time during the school hours. I shall go back when the school is over. Only thing, they chose to purchase a property in respect whereof they did not have possession. That's their choice. They could not have claim in future also because the deed says they shall not claim any right or possessory right. So if they have chosen,
been taken under section 14.
No, because the page 71 says deemed possession. I am in settled possession. But if they have chosen to do so, that is at their peril.
Possession, how can you say it is settled possession?
Because I have been in possession and their deed is recent. I have been there beforehand. But if that be the case, then on these facts, the learned lower appellate court could not have passed the order. And the clauses have not been considered also. Therein lies the perversity.
Anything else?
But I am carrying judgments my lord, on settled possession. On settled possession, my lord.
Whatever. You
At
have argued the matter. Whatever you have to hand over.
But kindly seize minute permit.
রেফার করেছে 1975
হ্যাঁ বলছি but kindly কোনটা 2004 one Supreme Court cases 769 but it is on the proposition of settled possession. Kindly seize paragraph 12. And this is paragraph 11 onwards, at page 777 of the report. In the present case, may I place it? In the present case, the trial court has found the plaintiff as having failed in proving his title. Paragraph 11. Having failed in proving his title. Nevertheless, he is found to be in settled possession over the property. Even the defendant, failing in proving his title over the disputed land so as to substantiate his entitlement to evict the plaintiff. The trial court therefore left the question of title open and proceeded to determine the suit on the basis of possession, protecting the established possession and restraining the attempted interference therewith. The trial court and the high court have rightly decided the suit. It is still open to the defendant appellant to file a suit based on his title against the plaintiff respondent and evict the latter on the former, establishing his better right to possess the property. The learned counsel for the appellant relied on the division bench decision in such and such to submit that in the absence of declaration of title having been sought for, the suit filed by the plaintiff respondent was not maintainable and should have been dismissed solely on this ground. We cannot agree. Such and such case relates to the stage of grant of temporary injunction, wherein in the facts and circumstances of that case, the division bench of the High Court upheld the decision of the court below, declining the discretionary relief of ad interim injunction to the plaintiff on the ground that the failure to claim declaration of title in the facts of the case spoke against the conduct of the plaintiff and was considered to be unusual. In such and such, the learned single judge has upheld the maintainability of a suit merely seeking injunction without declaration of title, and on dealing with several decided cases, the learned judge has agreed with the proposition that where the suit for declaration of title and injunction is filed and the title is not clear, the question of title will have to be kept open without denying the plaintiff's claim.
You do not say so. This is a question of title.
No, I am saying there my case is of possession. It's not of title.
Yes.
I'm led by Mr. Mitra.
Yes. Continue. It's 115.
First innings we did not get, but possibly in the second innings, Melody.
Yes, he'll come in, not now. Huh? Yes.
Well,
No, should I come back, that too?
He's already argued I gave him a proposal.
Yes.
He's not agreed to that proposal. I'll send, because you see, Mr. Mitro, today, at the end of the day, the injunction application has not been heard.
No.
And no finality can be attached to any of these orders. They'll be all prima facie orders subject to the decision.
True.
So all this effort ultimately may not inure to anyone's benefit. So I said that it was mentioned, citing extreme urgency, because sports is there, I cannot use or utilize it.
Absolutely.
So I said, very well. I'll send it back, permitting you to utilize for the purpose of sports on a particular date. Now, Mr. Gupta wants, no, I want everything, nothing short of anything else. Entire, whatever is there. So they had to argue the matter. Then what is to be done? Yeah, no. He said, yeah, whatever client instruct you, it is your matter. Then you will give up. So neither the court can ask someone to give up, because it is neither the court's own property. So
the court has.
But at the end of the day, you see, The injunction application has to be heard, Mr. Mitro.
Absolutely.
But
I may succeed, I may, my lord, fail at the final
Yes.
hearing.
So therefore, today I was
from an-
sending it back.
I'm sorry, my lord.
Yes,
Yes. From an appeal from an ad interim order.
Yes.
Ex parte ad interim order refusing to grant injunction, which is rare. Now, an appeal. Appellate court once passed order, my lord, we came up before this court. Your lordship has heard all this.
No.
Now,
I am not stopped you.
we came up before this honorable court. The honorable court had set aside the appellate court order, had sent it back again to them, to the valid first appellate court, or the appellate court. The appellate court passes a decree of perpetual injunction at that stage.
I will set aside that order.
And I will tell you, lordship, the
Yes.
whole difficulty, my specific case is that this area has all along been used by my client, my lord, for the parents, my lord, be there. Now, my lord, I can try to, my lord, even call a witness. I know, my lord, somebody who was from that school. Now, yes. The parents, my lord, gathered there to collect the children. My lord, during in Bengali, my lord, we used to call-
I understand the situation. But you see, at the end of the day, injunction application has to be heard.
Absolutely. Till that date, my lord,
You use it. He'll give permission. He says so. Not for parents. That cannot be. For sports, yes.
Kindly.
Very well. Then I'll be hearing him. Yes.
I'm sorry, my lord.
No. Why will you be sorry? Then I'll hear it only.
Yes.
When I'll fix it, you tell me. Then this cannot be any urgency. No, cannot be urgency in this. Cannot be any urgency in this. Construction, what construction? They cannot construct a building on that.
No. The wall.
Yeah, I'll permit if you succeed. I'll reverse that. Today there is an injunction. Please understand. Interim order passing in these matters, I have already heard him. And you will conclude.
Status quo to be maintained till that time.
No. I heard him. You come back, you conclude your arguments whenever. I'll fix a date. You can't conclude it. Mr. Basu, you will also conclude in one day. And thereafter I'll pass my orders. I think that will be better. If he constructs, assuming today if they have suffered an injunction, assuming he constructs a wall.
Yes.
And the court is of the view, no, he is not entitled to the order of injunction at this stage. I'll permit you to use it. To that extent.
Break down, my lord. It would lead to, my lord, multiplicity of proceedings. Nothing further.
Mr. Basu.
No. Why? They have, my lord.
Are you including the entire?
Yes.
I have put
No.
They have demolished. This matter, some portion that we are repairing.
No, then they stay your hands so far as repair is concerned.
That has been done.
As of today, then I'll pass a status quo order.
Why the status quo order will pass
In any event. No, that is the right. I'm not inclined to.
I will not.
Okay,
Will not make any construction. Nothing will be done.
When you want to come back?
Any day.
I'll fix the matter.
Send somebody as on date, my lord. Immediately send somebody.
Why do you want this?
No.
In
They have said
Order
that
39 Rule 7 application is not there.
they have said that, my lord, construction has been made of the wall.
Oh, to that extent.
Yes.
Mr. Mitro,
Or kindly.
I am hearing a revisional application. You'll correct me on this. Revisional application from the miscellaneous appeal.
Yes.
And my scope is now limited because today your opposition is also not there on.
Absolutely. I would show, my lord, the order is without jurisdiction.
Very well. So I'll hear you on that.
Absolutely.
And finally I will dispose. The interim order I can't grant you.
But in the meantime,
He's saying I'll record his submission. He's saying that he is not construct, transfer. One more. What more? What more is there? You want this? You cannot get a further injunction in his property.
The wall, my lord. Tomorrow an order, I get an order, my lord. Lordship will say.
I'll dispose. How many days you will argue the matter? Only one day, I'm sure.
Half an hour at best.
Yeah, already has. That's naturally.
Yes.
Already he has shown me the documents. I've seen it. Mr. Basu will do it, and I'll fix it in January 1st week itself.
In the meantime, my lord, if the wall is raised, my lord,
What will happen? I am taking Mr. Mishra's
ছুটি পড়ছে
if the
আমার
order
ছেলেরা
I'll fix it. I'll finish it off. I'll finish it off.
dismantle.
I'll finish it off on that date.
And my lord, with the undertaking that he
I'll
said,
record his undertaking here and
if
now.
they raise any wall, they will demolish it.
Yes, yes. Boundary wall, if I already raised, I will demolish it.
Very good.
আচ্ছা ওইটা ছিল তো চ্যালেঞ্জিং বলাটলা আছে বলা আছে হ্যাঁ The instant revisional application is filed. Mr. Basu, learned senior advocate representing the, although Mr. Mitro, learned senior advocate, appearing in support of the opposite revisional application CK.
So court is also appearing.
No, I'm recording this submission. Although Mr. Mitro, learned senior advocate, in support is for an order of status quo, comma. Mr. Basu, learned senior advocate, ably assisted by Mr. Court senior advocate, would submit that the respondents are, that the plaintiff opposite parties, how many plaintiffs are there? Plaintiff opposite party at present is not carrying out, at present night, does not intend to carry out any construction. Mr. Basu, you do not intend to carry out any construction.
No permanent construction is going to.
Do not intend to carry out any permanent construction in the property, and the nature and character of the property shall not be changed during the subsistence of the aforesaid revisional application. Full stop. Accepting such undertaking.
And if any partition, if any, my lord,
I'll protect you. I'll protect you and I'll give the final order. If you succeed, I'll give the final order, Mr. Mitro. Accepting such, he says that I'll not change the nature and character. So whatever is there today will remain.
that is exactly why I said that, my lord, kindly send somebody to see
No, in the
whether there
revisional
is
stage,
a,
I don't know.
whether they have made any partition.
And the revisional court, I don't know. You
Demount
apply
anyone,
for the trial
demount
court, you apply for the trial court will grant whatever relief.
I have to protect my property. School
My
student
lord,
property.
then,
I'm
my
the
lord,
owner.
no.
Accepting
Ownership,
that-
my lord, the Supreme Court has said ownership does not mean anything.
No, I'm not going there.
Possessory right is something completely different.
That you will argue, Mr. Minister. Accepting such undertaking given by learned senior advocate in court, accepting such undertaking given by the plaintiff through the learned senior advocate in court. Mr. Basu, instructions, on instructions. Let this sign adjourn and appear for final consideration under the same heading. Tell me a date, both of you. Agree to a date. Thursday, any Thursday.
Depends upon my lord.
No, Thursday, tell me. First week, don't say come up. Second week, you come up. Second week, you say. You'll finish it on a Thursday.
Thursday.
Thursday, usually I take this
Thursday.
returnable motion. But so far as this matter, it will be returnable matter. Or on that date, it will be taken up.
It should be 9th, my lord.
Second week? No, only we have 2 or 3 days in the first week. Next week, thereafter. 16.
16.
Marked. Monthly list, January. Monthly list of January. Mark 16. It will be called on, please. Although it will be there, whichever position it might be there, it will be called on serially on that date. And you conclude your arguments on that, I'll hear you and send it back. Either it goes back with the interim order or a modified interim order, because it has to go back. But it has to go back. Both of you agree on that.
Or
no interim order. Mr. Mitro, it has to go back. That you both of you agree. Because so make your submissions in a reasonable manner so that matters can go back to the trial court.
Lordship knows I am always unreasonable.
No.
To start with.
Before the vacation, it is not possible to hear of this matter. That's why I placed it on that. Otherwise,
Mr. Mitro is unreasonable only to start with. Then he becomes reasonable.
Yes.
Much.
Supplementary list item number 1.
You're there. My officers did not put it up on to be mentioned in the morning. So it is being listed now. Yes, sir. So you did not tell me on the last occasion that a surfacing notice has already been issued under 13.2. How is the suit maintainable? Challenging a surfacing notice, sir? Then I have come forward once again. Now a surfacing proceedings has already been initiated against you. While correcting the draft, I found out a surfacing notice is there and I directed its appearance. Yes, naturally. And you ought to have indicated. I do not go through all the papers while dictating. Whatever is submitted in court, sir, I proceed on that basis. Naturally, that is why I could find it out. Yes. So what is wrong in the order? Yes, what is wrong in the order? Very well, let it. Your suit is not maintainable here and now. You want me to return a finding? I will decide it. Court, Article 227, the court is competent. You want the court to decide. I will decide it here and now. Are you proceeding with the application or you want me to make observations? Make up your mind. Now, take instructions because otherwise I'll make appropriate observations here. Babaji পেয়েছে although an order Unsigned order. Stands recalled. Yes, please, your case.
So from that point of view, at least
Anything else? So you understand whatever is in the maintainability application, if this court decides this issue, nothing will remain. So that is why I have asked you to take into consideration this aspect and whether you would like to proceed with the instant application or not. Very well, tomorrow to be mentioned. Since the petitioner (13) proceedings are there, sir. Civil suit will lie. Sir, what are you doing, sir? Maybe matter ends. 13(2), the matter will come to an end. Very well, go. You want to argue before this court or you want to go and argue before that court?
No, my lord.
You make up your mind. If you want to
Come
argue
tomorrow,
before this court is ready and willing to consider all your submissions. I will hear you. Then no necessity to go back. And if you want, no, you will go there and argue, then I'll relieve you from here.
I'll come tomorrow.
Yes. I recalled, order is recalled. Unsigned order.
Daily list item number 9.
Vacating it. That was granted.
Earlier occasion, my lord, the question was put forward by senior counsel that the affidavit has been filed by the grandson on behalf of the petitioner, whether it is permissible or not.
Mr. Rai, just indicate the facts once again.
Yes. My lord, may I please, my lord? The mother is the owner of the property.
Take your seat.
Mother is the owner of the property. A purported deed of gift has been executed in favor of the opposite party, who is one of the son. Subsequently, a suit has been filed.
How many children?
3. 6. 3 sons, daughters are there. Not only one son.
Who has filed the suit and for what?
Mother filed the suit for declaration. The deed is void.
The deed executed by her is void.
Her is.
You are appearing for the mother.
I am for the mother. Now, my lord, the question court of initially an application for injunction was filed for additive order injunction refused. Against that,
mother filed the suit when?
Yes. If your lordship can turn to May 2023.
Of a document executed in the year?
Document executed in the year. Is it 2010?
After 13 years.
13 years.
And her cases, she was not aware with regard
to. Yes, paragraph 3 and 4 of this, what is following from your lordship, that is the specific. The nature of the document has not been disclosed.
Recently, she has come to learn.
Yes.
And this document, if kept outstanding, would interfere with her rights.
This is a summons substance paragraph 3 and 4. What is following from your lordship? That is the specific stand taken by the
ordinarily,
that is the stand, the nature of the document. Because my lord, if sometimes it appears a signature cannot be denied, then the nature of the document was.
What was the injunction that was granted?
No, initially no additive order injunction was not granted. that I have annexed also, my lord.
Very well, I'll rely on you.
No, my lord, it is my duty to point it out.
Yes, yes.
Against that, my lord, and miscellaneous appeal was preferred. During the pendency of the miscellaneous appeal, my lord, I do not know whether any order of injunction was there or not, but ultimately my appeal was rejected against the additive order of injunction.
Now you have come.
I have come before this honorable court, and this honorable court somehow admit my revision application and granted an additive order of injunction restraining them from disposing my property. Now disposition.
The document is outstanding.
The document is outstanding.
This court granted. This court granted.
This court, honorable.
This court, honorable court granted. Very well.
Now they filed an application for vacating of the order of injunction, which was passed by this honorable court on twofold grounds. One, they have annexed certain documents showing their possession of the property in question. If your lordship may kindly takes up the order of evident opposition.
The interim injunction application is yet to be heard.
Yes.
On the last occasion, it was agreed that it will be sent back.
Your lordship wants to do that.
I'll send it back.
But without any,
No, injunction cannot remain. I'll modify it.
because I will not sell the property.
So I'll record your submission.
Status quo to be maintained, my lord. That is
Status quo.
The fact that mutation is in my name.
Status quo.
Everything is
With the status quo. With the status injunction cannot remain. You understand? Not your suit. Or your suit.
My suit.
No. Your suit, but
It is
you
followed
did
by
not
my
secure-
lordship, the privacy position. It does not appear something, and the registered document is staring on my face. Unless the document.
Difficulty and galore. High Court passed an order.
I am not on
Continued
that.
for some time. Coming up for vacating. Order arising out of an miscellaneous appeal.
Yes.
Yet to be decided the injunction application.
That is why, my lord.
File objection.
No, nobody's.
Serve him now.
No, I could. Original injunction application.
I'll modify it and say.
Yes, it is there, my lord.
I'm in possession. Page 8 is very clear of my thing.
Page 25 in the revision application.
Page 8 is my.
The document is there in your favor, sir. The document has to go. Please wait, sir. Mr. Chandal, document has to go. The document will go finally in the suit. But in the meantime, if you create third party interest, please understand.
That's why in the beginning only I said I'm not.
Then what will happen? Then what will happen?
Because
Then possession cannot be protected because possession is his.
That, if you are logically
over to somebody else.
No, by the document, the possession is his. Sir. Privacy is.
that is the document. I have done because these documents are not before the court also. This is expert additive order of injunction. I have no occasion to impeach those documents.
Mr. Rai, your protection is enough, I think.
That is why I have status quo to be maintained.
Forget that.
Page
You will
25.
fight out everything. Now, Mr. Chandal, if your junior says all this, then if I have this court has to decide.
There's a suit to be
Suit will have to be decided. No, but
Page 25, your lordship fight.
I'm in
Mr. Basu is already trying to have a suit her out. In the morning, you saw.
That's why page 25,
Yes.
my lord.
No,
Fight.
I'll send it back. I'll send it back.
No, my landed friend is submitting.
I'm not going into that
No,
issue, Mr. Rai.
I'm not on the injunction. It is not been served because it is already there.
Serve him now.
It is there already. In the revision application, I have annexed.
That is
It's separate.
Mr. Rai, you get an order of injunction from the appeal court. And the order 39 rule 3A&B, what do? You say, I am serving you with the copy of the injunction application, and the injunction application is a verbatim reproduction of the plaint. So plaint is served on you. Can you say by that process the plaint is served?
Here, my lord, already
Serve him fresh.
Yes.
Because today either he has to waive service, he will waive service.
The injunction application copy.
Need not serve, it is there.
It is there.
The mark a true copy. Ask your advocate to identify the true copy.
Injunction ta kore.
Here and now, today, I'll record it.
Yes.
So that he waives further service. Matter ends. I'll give
right.
him some time to file opposition.
Yes, certainly, my lord.
And the court will decide.
And only one thing, my lord, I direct the municipal court to send out the records because I must
Misappeal is disposed of.
But
I'll direct the records to be sent out.
expeditiously because my lord, the records sometimes my lord kept in the appellate court and it has not been transmitted.
Unlike the High Court, without the records, the court cannot decide.
That is
Should be
the
aware of.
problem.
You are aware. Others, Sir, you are very clearly aware without the records, the matter cannot be heard.
কিচ্ছু করবে না।
Then, sir,
They'll not accept. That's why, my lord, I'm inviting
the
that
skeleton file remains in the trial court for the posting of dates, nothing more.
only for that purpose. That is why the record be sent out. No, no, এটা খুলে দিন।
Challenging
disturbing your lordship.
keeping these matters pending will not help anyone. And you cannot get an order of injunction restraining him from entering into
That matter
possession.
is over. Over.
Yes. Enough you have got.
My lord, we are the Bharted dome. Irrespective of the fact how he is dead, it is immaterial for us.
Yes.
Give us the dead body, we'll put it.
Item number 10.
Get put, your lordship.
Have you served? No.
Lordship have served. Lordship, now if they don't appear, my lord, that is a different
That is a
issue.
different issue. You have served.
My lord, I had by electronic mail, which I have been doing, my lord, electronic mail, my lord, we have served on 14th itself, affidavit of service.
Who appears on their behalf usually?
Lord, over here, my lord, I am unable to
No,
ascertain.
no. Only the advocate appears on them.
My lord, because Murshidabad,
Yeah,
most of
yeah,
the matters do not come before this honorable court because there are very few matters now since they have started this eviction proceedings. My lord will kindly come to the affidavit of service at page 5, at page 9. The electronic mail is there. And before the trial court, my lord, I have been informed that on the intimation of electronic mail, they appear. Now, my lord, what I can say, my lord, subject to my lord's correction, my lord, I may serve on the learned advocate representing them before the trial court, if my lord so directs.
Yes, yes. Tomorrow it will appear. I'll direct
My lord, because I also don't want to take anything ex parte. But my lord,
No, you cannot.
well, but I shall not. I want to, my lord, get this adjudicate that the thing which they have done.
What have you said?
My lord will kindly come to my can.
Which paragraph?
Can nikal.
Order had communicated.
Yes, my lord.
How?
My lord will kindly come. I'll come to, my lord, place the paragraphs one by one.
No, no, not necessary. I'll accept you. You
My
tell
lord,
me
my
where
lord, my
you
lord
come.
will kindly come to paragraph A5. First, paragraph 4. My lord will just recapitulate. At 11 o'clock, I mentioned the matter. My lord said mine was item number 7. 8.
I remember. I granted you that. Now, when that order was passed, how did you communicate?
My lord will kindly come to paragraph 4. Your petitioner, my lord has got can my page 4, paragraph 4. My can application, can 1. Lordship has got it. Page 4, paragraph 4. May I allow to be placed? Your petitioner states that my learned advocate on record, Sri Vikas Kumar Singh, prepared a letter dated 12/12/2024 communicating the gist of the said solemn order dated 12/12/24 passed by this honorable court as aforesaid order to the concerned opposite parties, marking a copy thereof to the officer in charge Newmarket Police Station, and handed over copies of the said letters to the brother of the petitioner, namely Rajesh Kumar Mal, for service thereof on the opposite parties and the officer in charge Newmarket Police Station, who was present in the honorable court at the time when the aforesaid order was passed.
Who was present?
The brother was present, my lord, in court, so we handed over the copy to him. Then, my lord, will kindly come to paragraph 5. Your petitioner states that as the police personnel from Newmarket Police Station had been requisitioned by the opposite party number 3 for taking possession of the tenanted room, thus the petitioner's brother Sri Rajesh Kumar Mal, after receiving the letter of communication from the learned advocate for the petitioner, first went to the Newmarket Police Station and reached there at about 12:20 p.m. on 12/12/24 and handed over the letter issued by the learned advocate communicating the gist of the solemn order dated 12/12/24 passed by this honorable court to the sub-inspector Madam Manoshi Kormakar of Newmarket Police Station, who was present there at that point of time. But that said lady officer, after going through the contents of the said letter of communicating the above order, told the brother of the petitioner, namely Rajesh Kumar Mal, that they would not act on such communication and directed the petitioner's brother Rajesh Kumar Mal to bring the copy of the order passed by the honorable court, which was being communicated by the said letter. The brother of the petitioner thereafter verbally told the lady sub-inspector that he is communicating the gist of the solemn order passed by the honorable court by this said letter upon leave being granted to do so.
You have made this person a party. Is a contempt application.
My lord, it is not a contempt. My lord, status quo ante, my lord knows. There are a series of judgments. Recent is 2024 of the Supreme Court, which says, my lord, that contempt, the first duty is to upheld. If an order has... And then, my lord, let me read the entire...
Servant come.
Then, my lord, I have got video recording, my lord, of that particular incident taking place at 1:13. that I have specifically stated at paragraph 6.
Learned advocate appearing in some
I think this Palach, under the heading application. ওপরে দেবেন মোশনের পরে
I'm indebted, Lordship.
will appear.
Indebted. My lords.
Despite service, none appears on behalf of the opposite party. Affidavit of service filed in court is taken on record. Despite service, none appears. Yes, call the list.
Great to me.
Item number 11.
I am appearing with the matter of Bar Association.
Your Lordship, I appear for the petitioners.
Let me hear the.
We have served.
Your Lordship, I had participated in the election, filed my nomination. Nomination fee was paid. I was prevented from filing my nomination. My entire Sarista was burned down. When I reached to the district court to move my injunction application, I was prevented from entering the courtroom. The number was.
You are appearing for the Bar Association. You would like to appear on behalf of the Bar Association. Would you like to appear on behalf of the Bar Association? You have been served with a copy of the Bar Association.
We have served them by email and as well as by, once again, I'm handing over a copy.
Now, here, sir.
Your Lordship, this is the case status.
Yeah, why did you come? I did not ask you. You wanted to appear. I would have directed service since you are now here. I can't give you adjournment. Why you ought to have not to have appeared in that case in the matter? If you come in and say that I will appear in the matter and thereafter election has been held.
Your Lordship, election has been held and
results published.
Yes.
Sir, nothing will happen, sir. In that process, you cannot think that you can circumvent the order passed by the court, sir. Yes, why did you not permit him to contest the election? Yes, sir. What is this going on? Allegation. Nomination paper allegation.
That is what 14th. We are on 16th.
What instruction he will take on this, sir?
The present body will not.
Whether you have allowed to file him nomination paper or not, tell me yes or no.
We have videographs showing the violence, Your Lordship.
Madam, what relief are you seeking today?
Your Lordship.
These are infructuous, A and B.
Your Lordship.
Then what relief are you seeking today?
I am seeking that the
go before the trial court.
Day-to-day hearing may be conducted and a commissioner may be appointed to adduce evidence, Your Lordship, because the entire, I have to demonstrate before the trial court that there was violence and I was prevented from filing my nomination. This is a case wherein all bar associations, similar cases, Your Lordship, if lawyers cannot file their nomination, nothing remains. The democracy is at the shoulders of the lawyers. We fight cases for others. We are not able to reach to court.
When did you file the application before this court?
Your Lordship, I filed my application before this court. First, leave was taken, Your Lordship.
Sir, kindly wait, sir. You don't have instruction, you said.
On 12th, I had taken leave, Your Lordship.
13th, you filed it?
13th, we filed it.
When was the order passed?
Your Lordship, on 12th, I was prevented from filing because it was a Friday. The caveat searching is done only till 12 o'clock. And post 12, no filing of civil revisions is permitted at appellate side. So I had mentioned again, next date, Your Lordship granted me for short.
No, last date of filing nomination was?
Last date of filing nomination was, Your Lordship, 7th of December, Your Lordship.
Then? What did you do on 8th?
Saturday, Sunday, it was there. So on the next date, I approached this honorable court. I had to file my civil revision before, plaint before the trial court, and then move to this court.
That was done on 11th. 11th, we moved the court.
11th itself, we moved to the trial court. On 12th, we moved here.
12th, we moved here. Then leave was granted.
WS has not been filed for expeditious hearing cannot come.
Your lordship,
WS has not been filed.
not been filed.
Sir, are you ready and willing to accept summons? Service of summons? Take,
Dada, ye
I'll record there, I'll record.
Respondent staff.
You are not ready and willing to accept service of summons.
Yes, sir.
Then some protection should be granted. You will say accept service of summons. Your junior is saying no. You will not accept service of summons.
Election Commission has been said.
Are you willing to accept service of summons? So far as you are concerned, you. Summons you will not accept. Challenging. I'm saying, sir. report, sir. Report in the form of a yes, sir. This is unaccepted, sir. You cannot make no allegation, but you cannot stall you whether a person does not file nomination is a different issue.
That's another issue.
Nomination is rejected, I would not interfere. But this goes to the question of administration of justice. This is a very serious allegation.
According to your lordship, the creating hindrance.
Yes.
To
You tell me, sir, you go to file a suit, you are prevented. So you are preventing the learned court from taking up a matter.
This is the allegations.
Maybe.
Allegation.
I'll test it out. I will test out the allegations, sir, with very seriousness. This cannot happen. Sir, you might do whatever you like with that election, sir, of yours. Your election you are contesting. The court is not going to interfere there. But it goes to interference with the administration of justice. The court will not spare an inch, sir. Because it is the duty of the court to uphold the majesty of law. Otherwise, public confidence in the judiciary will be lost. Election is different issue. Does not go into that.
Chapter 70.
This cannot happen. And your client's attitude, I do not know who is instructing you. He said that he does not want to accept service of summons also.
No.
He said so.
No, not that.
Ask him there. He's here in court. He's from which place?
According to him, according to him,
Should not. He should know he should know where to answer and where not to answer when a senior is appearing in the matter.
has been sent to election commissioner, not the bar.
Sir, maybe that is a difference. Sir, court will not interfere there. But whether it is a fact that this situation has occurred where a litigant is unable, lawyer, forget a lawyer, a litigant is unable to file a suit. Because if you have been prevented inside the courtroom, that is different matter. Then CCTV footage will be there. It is your case that you have been prevented inside the courtroom.
They did not allow the filing happens in a filing section, filing department. Only after the number is given, I can mention it before by way of put up before the district judge.
It is not permitted. You could have mentioned the matter before the court. Did you mention the matter before the court?
No. Before the trial.
তখনই তো সেরেস্তা জ্বালিয়ে দিল। তো what
Entire plant, everything was burned down. My old Seresta. I somehow I have been able to retrieve it from my service what I had served upon the other side.
from
I have put in CDs, hard compressed drive regarding the burning.
Yeah, I have filed the रेस्पोंडेंट्स को बोल पूरा 3 जन
Mr. Abdul Hamid.
That Mr. Hamid, learned advocate, has entered appearance on behalf of the opposite party number,
By the Bar Association.
opposite party number 1, and a copy of the revisional application has been made over to him in court today.
Your Worship, the suit shall be out
Copy of the
subject to
revisional
the
application has been made over to him in court today.
the present committee has taken charge. Your Lordship, the suit shall be the outcome of the suit shall be
That part the court will not go into, madam.
at present. Your Lordship.
Administration of justice, yes. That is your internal matter. That part the court will not go into. What happens in the suit, if you succeed in the suit, you will get it. But insofar as administration of justice is concerned, sir, you will also agree with this.
No,
This cannot happen, sir.
I do.
This cannot happen, sir.
No, I do.
If someone is stopped from filing a suit and an injunction application, so that will be loss of confidence entirely for the court also.
I do.
Much obliged.
Much.
Still matters are there in the supplementary list. Oh, no, better. At least some matters from the combined list should be called on.
Monthly list, item number 1.
One monthly list. এর আগে হয়নি? What for? Assignment, order 22. You are? Where is the other side? Sir, once again, in the absence of the other side, I can. Not today, let them come. They are not there maybe. Tomorrow, in their absence, I cannot pass the order. Can I dispose of this matter in their absence? Then, you want it in January, LPC is in January. First item, because it will retain its position. Before the vacation, if they do not come, what will happen? Serve once again. We are not appearing, you see. You serve once again, because I'll record it. Despite service, none appears on behalf of the opposite party. I'll make it not today. If tomorrow again the same thing happens, then I'll direct you to serve. Okay. Let us see what happens. But in their absence, sir, I cannot dispose of. You understand? No, sir. They have to be here. They have to be here. I will allow it. They have to be here. Otherwise, someone has some stand. Nobody knows, no? Someone denies the assignment totally. What can be done? Sir, I don't know. You are an advocate. You also do not know what the others will say. It is your case that your client might, it is most likely that this will go through. Call the next one. Dakota.
Item number 2.
Plaintiff is absent. The last order shows plaintiff is absent. 18th August. See that? Previous 18th August 2023. What is the stage? Order 22, Rule 4 is pending. How can there be an order for expeditious disposal? Order 22, Rule 4, whose application? Date of? Which defendant? Sir, I have to record in my order, I will dispose of. What will I do? From the same ground, this was adjourned. Where is an application? Who has died? Come tomorrow, sir. You want a disposal from this court. I will dispose it of, but I have to record it correctly. Who has died? So whose revision pending? First, that application has to be allowed. Now, thereafter, before that, nothing can be allowed. Yes. Interlocutory applications are pending. You want the suit to be disposed of. This is the reason why I wanted this document. Tomorrow, come tomorrow. Very well. Application is filed. Application has to be heard. অর্ডারটা ফেরত দিয়ে দাও, কালকে আবার নিয়ে আসবো।
Item number 5.
I have no problem. After vacation, if any date is fixed, is there?
Since an accommodation has been sought for on behalf of the on behalf of the petitioner, let this matter stand adjourned and appear. No. ঘুরিয়ে দেবে। হ্যাঁ।
Item number 15.
আগের দিনও ছিল না। adjourn হলো কেন? হচ্ছে করেন none appears. No accommodation has been sought for. Discussed.
Item number 24.
Sincerely submitted on behalf of the petitioner. এই কম্বাইন লিস্টে কোনটা কোনটা নেবে লেখা থাকে না? কোনটা কোনটা নেবে লেখা থাকে না? লেখা থাকে না কেন? আজ লেখা আছে? আচ্ছা ঠিক আছে, ঠিক আছে, থাকবে, ঠিক আছে, থাকবে। ঠিক আছে। Yes, yes, it is dismissed as it.
Item number 767.
You tell me what is the matter. At the time of call, the petitioners are authority has to appoint more advocates. On the next occasion, you will be there, so you can protect the matter. Yes.
Item number 43.
What is the order? Huh?
Opposite party number 4. No, only for 4.
Where is 4? Deepak Chakraborty.
I'm 44.
The added respondent. Why they have been added? Why? Yes. Why they have been added? Your title is your claiming title from whom? And he claims to be tenant under.
My lord, I'm not aware about. Or opposite party number 5. How he is claiming tenancy?
You.
Yeah.
Okay.
In respect of mine, my lord, I initially I was inducted.
Do you claim that you have any interest in the property?
My lord,
Do you claim you have any interest in?
I'm a tenant over the property.
Apart from the tenant, the right. Tenant has right
What has
to
happened?
remain in possession
What has
so
happened?
long it is not determined and etc. You have any interest in the property?
My lord, except for tenancy right, I do not have. My lord,
How are you interested in the suit?
my lord, initially I was inducted by the present petitioner. Rent receipt I have
Third
annexed.
party, you are a third party to the proceedings. Anyway, 5 is not there.
No, my lord,
Sir.
I've informed the learned advocate on record on that.
So nobody is quarreling on that. He is also not quarreling. So he said that he thought you are appearing after vacation in January. I'll place it in January.
My lord, the judge is not sitting, my lord. From my instruction, my lord, judge is not.
You come back on that date. I will make an effort and record all this. You come back on the January monthly, same position, item 43, it was here. Most of the matters are over. I'll keep it in top. It's in the first group only. You come back on January, first group. Unless you are contemplating a change, then I let them proceed with the suit. On the next date, what will happen? January, the matter will be there. And
My lord, I have filed my court is vacant. My lord, judge.
most of the matters are over before 43. Few matters have been adjourned and those will not sit over you. Your matters will be item number 2 or 3 in the monthly list. Naturally, it has to be from a group 1. Court will not assure anything. গ্রুপ ওয়ানে কটা আছে 3-4টে আছে তো গ্রুপ ওয়ানে হ্যাঁ গ্রুপ ওয়ানে কটা আছে বেশি থাকবে না কিন্তু এটা তো গ্রুপ ওয়ানে হলে এই নম্বর এর উপরে নম্বর থাকবে এই তো এরকমই থাকবে হ্যাঁ what can be done since the respondent number 4 and no, I'm saying, is the cross-examination going on of your client? And that has to be expert, simple. If he's removed, everything will be gone. I'll hear him without hearing 5 on this. Liberty to the petitioner to apply for an adjournment. Liberty is granted to the petitioner to apply for an adjournment before the learned court on the next date so fixed. Only on one date. Next date so fixed. January, I'll take it out. Yes, call the next matter.
Item number 45.
It was not allowed.
Thousand 2014
What is the suit for?
suit for partition and declaration. Suit for partition and declaration. It is a preemptory stage.
Next date is, tomorrow is the date fixed for PW1.
Which paragraph have you said that all interlocutory applications are over?
Yes, sir.
Where? Which paragraph? You did not annex the entire order sheet. Which paragraph have you asked for?
Well, kindly, for paragraph 7, paragraph 6, 23rd January 2024 was the
Commission
date
proceedings
for
are over.
evidence.
Commission proceedings is over.
No. No.
Then you want the suit to be disposed of?
Should, directly like to dispose of the
Suit.
preliminary degree.
Suit itself.
Preliminary as preliminary degree will be passed.
2019 an order is already there.
Yes, my lord.
Why? What happened?
Several occasions.
Why the court will repeatedly pass orders? If an order is passed, which is not complied with, this court will call for records.
Kindly see, my lord, I have put it 17th February 2022. The plaintiff petitioner filed an application, order 22, rule 3 for substitution. That was my lord. Thereafter, directing the petitioner to file amended plaint. Amended plaint was filed 25th.
From where are you reading? I don't have the papers. From where are you reading? I don't have these papers.
Yes. Paragraph 5, 14, 7, 2020.
No, where is the order sheet?
Yes, my lord. I have annexed, my lord. 14th March.
The instant application is an application.
4.5.
Praying for certified copy, sir.
A plain copy of the order I have taken, my lord, from the record, my lord.
Item number 46.
My lord, this is my application under section 24. To avoid conflict of judgment, I am praying for analogous hearing before the two matters in two courts and same division. Senior division, Diamond Harbour, second judge, senior division, Diamond Harbour, second civil judge, junior division, Diamond Harbour. My lord, I am praying for direction for analogous hearing for conflicting of judgment.
Where is your application? Where is your application?
Because the court below.
Yes.
No, I have not filed application.
Without passing of the plenary decree in a partition suit, you want the suit to be disposed of within 3 months.
Plaintiff, defendant, I am the plaintiff in one case, or defendant in another case.
Where is the plaint?
Plaint, my lord, I am praying leave for annex the plaint.
I should have dismissed this matter.
No, my lord, I am praying for
Yes, call the next matter.
Item number 47. I was sorry in earlier matter because one matter was going on.
This matter also you are sorry. Yes, sir.
Name be recorded in earlier matter. Name, authority.
Yes, sir.
Dependent is the petition of the lordship. Plaintiff's prayer for amendment of plaint has been allowed against that. The suit is for declaration and on the another prayer is there.
What is the amendment that was allowed? Why are you aggrieved?
The present plaintiff is 45 years old in 2024. He's challenging the deed up to 1962 and 65. He is not born even then. First of that. Secondly, minor note. Reason is 3 years.
Limitation for?
Challenging the deed and declaration.
Where is the plaint?
I am the defendant.
The plaint, which place are where is the
Plenty of errors.
which paragraph they have inserted?
Page 8 is plain. This 14th subject is the trouble of controversy. They are claiming title of 14th subject which they have sold to my predecessor in 1962. Admittedly, the next page 10, 26th of the admittedly belongs to us. They have sold it to me. I don't know in a suit for this. If the plaint limitation can be condoned, Section 5 can be applied in case of appeal and in case of application, not in case of original suit. Section 3 and Section 5 of the Limitation Act. Their father, the person who executed the document, they didn't challenge it. Their son didn't challenge it. And the third generation is coming. Volume is there, is the notice. Why possession is the notice? Kindly see the cost title, the address, side by side property. Ribbon will look up from the slumber from 20 years. And the Lalit trial judge consider this aspect also. Reason is not always the bar, but the explanations must be there and then the circumstances to be considered. Another significant thing by I wish to I can show it.
Paragraph 17, the plaintiffs now claims knowledge from 2023.
That is why by giving a searching in the ST office. that is available anytime, we can go and get it. Caveat emptor, minor knows the perform the caveat emptor, bad we are. Possession is the rest is the volume is the notice.
Yes, and which paragraph he has incorporated by way of amendment?
That is the paragraph I'll come to. And 17. My purchase of 66 is admitted.
So the suit is there. Bad, ugly, indifferent, not good looking, not so good looking, still has to be decided unless you seek for rejection thereof.
I don't want this. I am
No, I'm saying suit is there. You argued on limitation. It is not that for the first time by way of the amendment they are trying to incorporate something so that it will be barred by limitation.
That is one of the points.
Correct.
One of the points.
No, you stress so much. That is why I said there is one point.
That is the first point because in the original.
Because in the suit he challenges that deed.
No, not exactly.
Yes.
This is my settlement deed of 1983, and he has admitted the challenge play for 30.
What prayer he has included by way of amendment? Any prayer?
Kindly can page 15, prayer portion. Kindly see prayer page 15 for God. Not that he has challenged that the 66 to be is void. It is not his case that those two deeds are void or voidable. And the earlier generations, they have not challenged it.
That is a go to court to go into.
Acquiescence and
Sir, this court cannot go into that aspect. Neither could the first appellate court go the court go into that issue because at the end of the day, that issue will have to be decided and tried in the suit.
one thing
Acquiescence, you have to take a point. Where is your written objection to that? A written statement, a filed written statement.
Kindly see my permits me. From my
I have to hear the matter anyway. Maybe only one point is there. You have added one prayer, Mr. Mukherjee.
But only thing that happened, but when I came to learn from the written statement, my specific case in the amendment, that I have no knowledge about the deed which has my learned statement has relied upon. I came to learn from the written statement, and then I applied for amendment. Now, the suit is at the injunction stage. Issue has not been framed, evidence not started.
He is not in possession, he is in injunction. Porcha is in my name.
Now, what happened, my lord? There are three parts. One is, my lord, that at the time of considering the amendment, whether court can go into the merits of the proposed amendment, I will argue on that. Second thing is that, my
Not necessary to argue on that. But the court will certainly consider whether the amendment incorporates a relief which is barred by law. Exceptional cases, the court may make all amendments are prospective.
absolutely.
All amendments are prospective.
Under the Limitation Act, from the date of knowledge, 3 years.
But the court can also make it retrospective. What has been done here? Prospective.
Now, what happened?
Kindly excuse my impertinence. He might have permission to do
Only one thing I will.
Relax, no, sir. Mr. Mukherjee, why are you getting impatient on this? He will submit. He is making his case. He is anxious for his case. So why are you getting impatient on this? After all, you are getting an opportunity of hearing.
I can't.
Please don't be impatient on this. Yes.
Yes,
please.
Keep a brief copy. I marked it for myself. Kindly excuse me.
No, I will consider it later. But let me hear from him. Let me hear from him a little while and thereafter.
But I have something more to say.
Yes, I am not deciding it. So, Mr. Mukherjee, I'll hear it the matter. Because this cannot be heard on this side. Amendment has been allowed, consequences, you know.
Oh,
Either there has to be, either it can be that I will hear out the matter and decide it, which would ordinarily I do, but very difficult to hear out now before the vacation. After the vacation, I keep it. You will not proceed with this suit.
63
Or I pass an order of injunction restraining you from proceeding further.
They are enjoying injunction already without being in possession.
Sir, that is different. Sir, unless this agent,
The record of rights is in my name.
sir, I cannot go into that aspect. Only limited, sir. Question is.
Minor will take a private view.
No, I will not go there. I will only consider whether the amendment could have been allowed or not.
After vacation, any day, my lord, but I think.
Not fixed. It will normally appear. Yeah, as a returnable motion. As a returnable motion. January are all filled up. In February. And you will not proceed with the full. You are enjoying an interim order.
But kindly keep that thing silent because that will be prejudicial. Already he is enjoying injunction. My lord is if some addition is there.
I am not adding. I am clear. See what order I pass.
Injunction order, my under senior
My-
has not challenged.
No, I will not go there.
Who says? Who
I
says?
not this is
I
not
have
not for this
objection.
court to consider that issue at all.
I have 5 order 7 to 11. I have
Challenging the
objection.
order number 7 dated 8 February
Kindly
2024.
excuse me for a moment. Am I excuse my impertinence?
February 2025. February 2025.
Grateful, Lord.
As a returnable motion. These are different groups, so it might change the
Generally, limitation is no bar, but some unless it is expressive. And the distinguishing feature is that the application and appeal, section 5 applies, but not in the original proceeding.
Yes, sir.
That feature I shall try to impose with my limited knowledge.
Certainly, sir.
This point has already been decided in 2000.
Anyway, why are you anxious today?
I am
On the
anxious
next auction? No, earlier matter is over.
Not my case. Not my case. My
Nobody is named. Nobody was there in the matter.
what was going on before the unfolding. Finally, because it's not my fault.
What are these? Mr. Mukherjee, Raj Junior. Accommodation change.
Just a minute. Before-
Sorry to disturb
No,
you, Lord.
sir. Sir, it is with the interactions that the court has, that the court gets enlightened. And so this is a process. This is a learning process. So far as this court is concerned.
Still I am learning after 54 years.
Sir, it's a learned person. So this court gets an opportunity and gets sir, enlightened by the advocates who render great assistance to the court. And I would say this is a civil court here. I had the opportunity to take up matters in the appellate side under initially under the group 3 matters. Then they learned
That's what also I was saying sometimes.
Yes, yes. In all these spheres, I tell you, our bar provides brilliant assistance to the court. And it is the multitude which really matters. Few people are exceptions. They are all there. Luminaries are there. But the general multitude, they matter the most. And they really speak volumes of the bar that we have in this court.
Previously, I thought of so many things. Then I have cut short my argument. I have confined myself to a particular 1 or 2 points.
Come back on the next.
Grateful, my lord.
Original side.
Grateful, my lord.
Well, may I have your lordship's leave to mention? But I'm sorry.
Wait, it will be taken out. Please hold on. You're mentioning in the morning in the appellate side.
I was.
An original side matter.
Yes, my lord. I was not aware that
You're
mentioning
not aware.
on the original side mentioning is taken up at 3:30. My lord.
You're aware that the original side matters are taken up at 3:30?
Yes.
Yes, what do you want to mention?
This is a clause 13 application, my lord. The suit is of 1988, my lord. Suit is pending the stage of cross-examination of defendant number 1. The original cross-examination of before the court at Katua, civil judge junior division Katua. My lord, several orders were passed by this
Why
honorable.
will they take up the matter?
My lord.
Why would you want the court to take up the matter?
My lord, this is not appearing in the monthly list of this court. I am praying for inclusion.
Oh, rule has been issued.
My lord, this application has been filed, my lord. Rule has not been issued. Application has been filed.
January से दिए
ALP 3 of 2020. Grateful.
Original side listed matter under heading extension of interim order serial number 1 Komal Kumar Hirawat.
Lordship, I appear for the petitioner. I was enjoying an interim order of injunction dated 5th of July 2024, which expired yesterday, Your Lordship. It was a Sunday. It had been extended last by an order dated 22nd November 2024, if I may be permitted. It had been mentioned on Friday, Your Lordship. Your Lordship has been pleased to place the matter today.
So this is a matter pertaining to Justice Kapoor.
Justice Kapoor's
determination. So this court does not have determination today.
Your Lordship, till today, Your Lordship has.
Justice.
Your Lordship, the interim order had
Yes,
expired
yes.
yesterday, Your Lordship. If a limited extension would also suffice. In the meantime, we shall mention it before Justice Kapoor when he resumes office, Your Lordship.
देखिए original interim order देखिए.
5th of July 2024, Your Lordship. This pertains to
Where
my.
is your notice on the other side?
Your Lordship, the other side is not appearing. It had been moved ex parte and thereafter on all dates of hearing, they have not appeared.
None appears on behalf of the respondents. Reimposed.
Yes. To be mentioned serial number 2 in the matter of this Dunlop India Limited.
This is my application, my lord. 446 for leave to proceed.
Execute the deed of conveyance in favor of them by the official liquidator. Lordship, I'm praying for 2 weeks' time to file an opposition, Your Lordship. Because since it's a leave and proceeding is pending, seeking for 50% ownership, Lordship, opposition is required to be filed in this matter.
Well, it's your lordship's decision. No, he wants to file an opposition. Why will I deny him? Obviously, man, I cannot stand in the way also. Since the official liquidator seeks leave to file opposition to the instant application, CA 346 of 2024, comma, let affidavit no, after reopening. CFs after reopening. Yes. Well, 1 week you get. You file it before the matter is taken up, I'll take it up. Yes, yes, madam.
Under heading code application serial number 3, State Bank of India.
Lordship, in this matter, Lordship, actually, I have not annexed any of the documents. Lordship kindly permits me to file a supplementary affidavit incorporating all the documents, Lordship.
Take back.
Let it.
Take back and file afresh.
Lordship, kindly permit me to file a supplementary, Lordship.
Clause 13 application, nothing, you have annexed nothing. Take back and file afresh.
Liberty to file afresh then, Lordship.
The learned advocate appearing on behalf of the petitioner.
New company application serial number 4 in the matter of Mr. Dunlop India Limited.
My application.
Yes.
It's a secured creditors application, my lord, for a direction on the official liquidator to disclose the list of creditors whose claims have been received by the official liquidator in connection with the liquidation of Dunlop.
Why?
Because there's an amount of rupees 10 crores which my client, pursuant to the company court appeal from the order of winding up, it is lying deposited.
Are you entitled to this?
Yes, as per the provisions of the company's court rules, I am.
Show me.
But there were several directions on.
I wait, I'll let you.
My copy of the company's court rules. If your lordship kindly permits this to be handled.
What is this?
The company's court rules.
2019 59.
59.
Yes, 59.
But kindly sees.
I haven't got 59. The dosher boi nahi hai.
আরে ভাই পার্ট 2 এনেছো সত্যি তুলে দেখো
এতে পাবেন রামাইয়াতে পাবে ফোর্থ ভলিউম পাঠিয়ে দাও Anyway.
Lordship will kindly have a look at.
Anyway, Mr. Gupta has favored this court with this. I'll retain this for future reference. After this matter is over. Yes.
But my book had come, but a different part has come. So I am also relying on this. It's there in the appendix 1. My clerk has got appendix 2.
It is the part 4. Oh, this is the new volume. So
New volume, the green one. The
green
new
one. I don't know which part. So
it's appendix volume 1.
appendix
Volume. The volume 2 has come. So I am also relying on this.
Tell me, Mr.
Yes, my lord will kindly have a look at rule 167. Fortunately, this has not come with any pagination. What we've downloaded, but the
As long as it is giving a correct truth.
167, my lord will kindly have a look at. Proof and
Yeah, official liquidated to file it in.
Yes.
Why are you entitled to that same and now?
Yes, because I am entitled to that, my lord, as per the rules. My lord, if your lordship kindly permits me to place 3-4 rules, my lord, and this is 167. Proof and list of creditors to be filed in court. In a winding up by the court, the official liquidator shall, within 3 months from the date fixed for submission of proofs under Rule 147 of these rules or such further time as the court may allow, file in court a certificate in Form 71 containing a list of creditors who submitted to him proofs of their claims in pursuance of advertisement and notices referred to in Rule 108. The amount of debt which they claimed to be the creditors, distinguishing in such list the proofs admitted wholly, the proofs admitted or rejected in part, and the proofs wholly rejected. The proofs with the memorandum of admission or rejection of the same in whole or in part as the case may be endorsed and shall be filed in court along with the certificate. Now, we will kindly have a look at Rule 169. I'm sorry, 175.
It will be open to inspection.
It may be open for inspection to any credit. That is one that your lordship has seen. Now, kindly see is 170.
No, if it is open to inspection, then you are entitled to the same.
Yes, and also
Go and take inspection.
In my book, it was marked, but
Madam, give him inspection
yes,
of
and also one.
The locus of the on what capacity we are filing this application that is.
No, madam. If it is open for inspection upon payment of a fee, company proceedings after at the end of the day, how can you hold back?
Lordship, first of all, your lordship, there were on the earlier occasion also there was a direction because there was a direction upon the applicant to pay 3 lakhs. That has not been complied. So
No, that is not in connection with this. I'll indicate to your lordship. I'll indicate to your lordship what?
There are 7 filed earlier, your lordship. Honorable Justice Bojpai Bhattacharya has been pleased to pass.
Slowly.
Lordship, I will bring my apology.
Slowly.
So that compliance has not been done. Appeal has been preferred, your lordship, but no stay is also there. So my lord has also been pleased to direct them.
Already,
May I indicate?
Mr. Gupta,
May I indicate
previous
one?
order, the previous order, Mr. Gupta, I passed an order in the matter. I cannot also, if I want, change this. I mean, you ought to have told me this order is there, Mr. Gupta.
But my contention is that is in respect of a sale matter.
But
that has nothing to do with the creditors. This is a right
order has
in
been
law.
passed in this matter. This matter on 29th of August.
Yes, I have this order.
Mr. Thakkar said on that location, what happened to that appeal?
It has not been taken up. It has not been taken up.
So there is no change now.
May I only indicate 2 things, and I'll leave it to your lordship. I'll only.
No, I say there is no change. I'll go out. There is no change now.
Only one thing. May I only indicate one thing? Possibly, that matter where the order for cost was passed was dismissing this applicant's application.
That is different.
For
I cannot
challenging a sale, but
then
this
you
is
have
a
to
matter
prefer
of
a
right.
review of this previous order.
I understand, but this is a matter of right where, as per the statute, all the creditors are entitled to this.
No, so far as you are concerned, you are not, because 3 lakhs you did not pay.
No, that is for a sale matter. where one of the properties of the company liquidation was put up for sale. We had said that that property belongs to.
Not adhere to the directions passed by this court. You are not entitled to any order. That is what is recorded in this. Kindly see the last
But
paragraph.
this is a cause, my lord, which any creditor can espouse as per the provisions of the
Mr.
act.
Gupta, this is recorded in the order. Now, if you are agreed by this is a different issue, you should have moved up. You can't ask, then you have to ask for review.
But
I have the difficulties, I have passed an order. I cannot go whims and fancies. Tomorrow, no, today I pass an order, tomorrow no, that order let it be recalled. Right? Refuse to grant you relief. I have refused to grant you. See the order, third paragraph, Mr. Gupta. Having heard the learned advocates, respective parties, I am of the view no relief can be afforded to the applicant at this stage, as there is no stay granted. Specifically, I have indicated.
I was trying to only impress upon the court that this
I
is a different.
appreciate, but you ought to have come then. This order remains. Either you prefer an appeal, set it aside, or you pay 3 lakhs and you come.
Or prefer a
High
review.
Court, yeah, whichever. High Court has passed an order. You
Lordship
will,
has passed.
the company court has passed an order.
But that we have challenged. There's an
No, what
appeal.
challenging will not do. I've recorded that. You go.
Appeal, my lord, to
You
get
will
it
not adhere to
included.
that order. You will come to the court. You will say, no, I will not hear that. This is another cause of action. You hear me on this. Okay.
I shall.
Go out. No order on this matter. Because there is no change in circumstances. No, there's nothing. Why the matter came up, I do not know. Yes, let's go out.
No. It has been appearing. Last week also it had appeared.
Yes.
Let's
go out. Urgent. Appear. Let this the matter in the month of January 2025.
But then kindly makes it February, because
February
by
20.
January.
Yes.
Because the appeal court is not including any new matter for inclusion. Very well, we shall try.
The stay from that matter in the matter
has to be
ends.
included in the list for getting a stay. I say no mention for
3
inclusion.
lakhs is the only amount. Or pay to them. Hence, pay. Or don't tell me that.
We shall try our.
Whichever way you want.
Whichever way I can.
Naturally, including going from this order, whichever way. There is no difficulty.
I think the easiest is to come before your lordship with a review.
Difficulty is unless you have not adhered to an order. High Court passed an order, and say
But that's a completely different thing. That's a company court sale of one of the properties which they are saying that sale notice is legally banned for non-compliance of certain provisions. That is the fact.
With costs.
With cost.
Cost was not paid.
Cost was not paid, and we have challenged that order. Their appeal is
Other way
pending.
to implement it.
And your lordship is implementing it.
No, I'm not. I'm saying that if you do not adhere to a court's order, you are not entitled to an order. That is what I've recorded also. That is what I've recorded. You are seeking an order from the court. You comply with the court's direction. You will not comply with the.
No, your lordship will keep
No,
it. Otherwise also it will. Your lordship would be required.
Very well. I'll keep it. Tagged with this matter or
No, otherwise.
Yes.
Otherwise. At least your lordship will grant.
Matter in the monthly list of February 20. January রাখো আবার তখন February করে দেবো ওরা তাহলে প্রেসারে থাকবে
January আগে list. I'm sorry.
You will do something. You will actually do something if it is there in the list.
Yes.
February. Otherwise মানে হয় না তাহলে জানি both 4 and 5.
Only 4. I'm only in 4. 5 I don't know. There are several Dunlop matters. I'm only in 4.
5 is a different matter.
5.
I'm for the official liquidator unit.
না তোমার কাছে রাখো না রেখে দেও না আমার কোম্পানি মামলা ছাড়া তো লাগবে না কোম্পানি মামলা যখন হবে তখন দিও চাইলে যেন দিও
Applicant is not before your lordship.
not today not today no, after vacation none appears on behalf of the applicant. No accommodation has been sought for in view thereof
Monthly list of
to
January.
provide one more opportunity to the applicant to appear.
Monthly list of January.
List this matter in the month list of January.
Company matter adjourned, serial number 6, Dunlop India Limited.
Your Lordship, Mr. Sarkar is appearing in this matter, but I'm praying for not today, Your Lordship, because due to his son's marriage occasion today, he is unable to appear.
The monthly list of January, my
Lordship.
On the prayer of the parties, list this matter in the monthly list of January. On the prayer of the learned advocates for the parties. Parties did not pray. You advocates. Difficulties of the advocates, sir.
7, in the matter of Mr. Dunlop India Limited.
I'm for the official list. But they have filed, pursuant to your Lordship's direction, a supplementary affidavit has been filed. I need to answer that because a letter be a direction for filing a rejoinder to the supplementary
Come
affidavit.
up with it on the
Because they have, may I come up?
None appears করে ওই আগের order. After vacation,
Let it be recorded, then let there be an
after vacation, you bring it on. Bring your response. Right.
because the pleadings were complete.
At a line তলায় জুড়ে দাও, the petitioner, the official liquidator shall be at liberty to use rejoinder in the meantime. To use a rejoinder in the meantime. Rejoinder reply, madam. Rejoinder.
Supplementary affidavit. So it is a reply
Rejoinder
to
to the supplementary affidavit in the meantime.
8, in the matter of Dunlop India Limited.
8 and
Yes,
9 can be
Mr.
taken up
Chakravarti.
together.
Yes, 8 and 9 is together, Your Lordship. Today, if your Lordship
Yes,
pleases, that
yes,
it is this-
continue.
hear it out. Your Lordship, two applications, CA 141, I'll just address Your Lordship on first. That is an application for 369 employees. When Your Lordship, the affidavit in compliance of the official liquidator's mandate for ascertainment and disbursal of the dues, it was submitted. However, it was time barred. Your Lordship, just one document, I think so, I must take Your Lordship through in the interest of propriety that Your Lordship would find on page 59. That is a minutes of the meeting dated 5th September 2022. Your Lordship, something else that I should have stated at the inception, I apologize for that. On the last occasion, Your Lordship, the pleadings are complete now, Your Lordship. I had pointed out because it was a changed brief that we had not received a copy of the reply. We've received a copy of the opposition and the reply has been filed. We'll just file that in with Your Lordship. We've served a copy upon them.
Only 2 days back, I have been able to receive the replies. But
days
this is an application with regard to some of the employees of the union is before your Lordship.
Yes, sir.
Now, already the official liquidator has adjudicated the claims of some the unions because there are several unions coming up with the names of the workers, which if it has been adjudicated, then it's found that there is a mismatch with all the names, and in sometimes it is also found that there's a repetition of the names in the claims. So this is a problem which the official liquidator is facing. So my instruction is that
Let him find this. You check up and come back in that case. Whatever
we
you
have
want.
already checked up
Yes,
and
then
we
you
have
argue the matter.
arrived at a conclusion that they are the same workers coming up
Identify.
one after the
Same
other.
way not. Then you have to identify.
Your Lordship, with utmost respect to my learned senior, it is not
Madam,
the
then you have to
case.
identify.
Yes, sir.
Because
Making a sufficient will not do. Yeah, does your opposition?
Yes, my lord. If your lordship kindly takes up the opposition once, my lord.
Mr. Chakraborty.
Yes, Your Lordship. Yes, sir.
What are the two documents, Mr.
Paragraph
Chakraborty?
5, my lord.
It is the reply, Your Lordship, affidavit in reply to their opposition for CA 141 and 142 and the affidavit of service.
মনে করিয়ে দিয়ে রেকর্ড করে নেবো পরে যাওয়ার আমার একটা দাও শুধু হ্যাঁ এটা দিয়ে ইয়েস ম্যাডাম
Page 5, my lord. It's a continuation of paragraph 5.
এই দাও আমাকে রিপ্লাই এই অপোজিশন দাও
May I place only the relevant portion of the paragraph 5?
রিপ্লাই
It is at page 5, my lord.
where is your opposition ম্যাডাম
I have already filed the opposition.
দাও তো yes
March 23.
which page madam
Page 5. That is actually the continuation of paragraph 5. But may I place only the relevant portion? Page 5, my lord.
page 5 starts with para 6
Yes.
Yes.
Page 5.
Ma'am.
This is for 142.
141 is going on, madam.
Yes, my lord. Page 4, paragraph 5, my lord. Your lordship kindly comes at the bottom of the page 4. It is apparent that the applicant in the series of the communication has made conflicting and skeptical statements, and through the present application, the applicant union has claimed to have represented 369 number of employees for their manifold higher demand, including the area wages for 126 months, which is astoundingly inflated and fabricated. Then if your lordship kindly comes to paragraph 7, middle portion. It starts from the middle, that the sole purpose. My lord has got it. The sole purpose of such meeting was to remove all the misperception and the differences so that all employees' unions could come to a consensual decision regarding the settlement of workers' claim. Although the matter of fact is that the minutes of the meeting is not much instrumental, since the claims of 445 workmen were already settled back in the year 2021. More so, the applicant's representation barely for 369 employees is sheer ambiguous and confusing, and especially given the situation that the claim of 445 employees has duly been settled by the respondent, that includes the allegedly mentioned total number of 369 claims. For the sake of clarity, this is to explicitly state that the respondent's only motto is to prepare correct and exhaustive list of workmen of the company, regardless of the nomenclature of the unions or their political affiliation. The respondent is striving to genuineness of the workmen and the authenticity of their claim as individual. Thus, the respondent reserves the right to reject any claim in whole or in part if found improper, inflated, or unauthenticated or whatsoever. So this is the conduct of all the applicants before your lordship.
No particular
Already they have lodged their claims. Now,
on the basis of this, your contention won't stand at all.
but this is the official liquidator is the competent authority to
Tell
adjudicate.
me, you
And they have
saying that
already
I have seen
adjudicated
everything will not to give me particulars in a chart.
particulars in a chat. Then I have to come back with that
Nothing-
statement, my lord. And if your lordship kindly comes to paragraph 15 only
No,
the
then you come with whatever you have. Show that in their case already adjudication is complete. Because Mr. Chakraborty's contention is absolutely different.
voluminous, my lord.
Maybe.
Because 369 workers they are claiming for their they are for their entitlement, but they have already been paid
Show it
way
to
back.
Mr. Chakraborty.
Your lordship, my instructions.
Then they can make an
subject to
inspection of
correction.
those.
Yes.
That will
Mr.
be better.
Chakraborty, sit together, take an inspection, find out whether everyone is covered, and identify the persons who are not covered, and give those names to court.
Your lordship, that is why we came up with CA 142, because 142, the gamut of persons are the 133 employees who have not been covered. 369, they have been covered. But since we were time barred in submitting our claims, that is not now being taken into
That is
consideration
no,
by
she's
the.
not saying that.
Your lordship, subject to correction,
But
what
if
my
your lordship,
senior
so,
is saying.
no, if this is 142, if they are praying for that, so that leave can be granted, so they can then lodge their claim. But that will be entertained or not, that is the question, because already they have.
Once the court grants a leave
then
to make a claim,
Because
you cannot
a
reject it on the ground of
proof.
being out of time.
But my lord can always extend the time. My lords can exercise the power under
So
Rule
therefore-
6 and 9 of the company's code rules.
So therefore, you cannot thereafter dismiss it on that ground.
Because
reject it.
already this has been adjudicated and there will be a further re-adjudication of the
If
claims, my
necessary,
lord.
if so be it.
Then
After
I
all,
have to come back with a chart that who are there, because it will be voluminous. Let them make an inspection. This is the only what
369
diverts them from
voluminous.
filing it is because they are out of time.
How many pages? 369 will come in. Not be voluminous. 369. Only.
Because out of which I think so, I believe 140, no?
130.
130. Because that there is a repetition of the names in the claims itself.
Your lordship,
Because the
133 has
unions
never
or the
been submitted.
139 never submitted, so
submitted.
they won't at the billeted
That is 142.
That is 142.
142. So they
339,
for
369 have been
filing.
submitted. Those have been rejected as being time barred.
Time bar. And also,
Time
They
barred.
say, which you are not saying.
Time bar, that is a different issue because
You check up, madam.
we have
There
already
is
checked and we
nothing to-
will not be entertaining because already they have been paid. That's what we
Come
are
back
saying. That
tomorrow,
is why
madam.
it's
Check
a
up.
lot.
It's 4:30 now. Come back,
That is
check,
why their claims have not been entertained. It's
Your
because
Lordship,
it is for
check up
the,
and come tomorrow.
Your Lordship will just kindly take page 59 once.
No, no,
and I
let
will-
us check up and come tomorrow. Same, it's
No, I
4:30
appeal,
now.
I bow down to what
Because
is
it's
calling for
4:30 now, I can't dictate it.
No, no.
So
I
come back
bow-
tomorrow.
it's
I will grant leave. So far as 133
Three is
is
140.
concerned, I'll grant leave. Because you will examine their claims. If you find their claims are not legitimate, you'll reject it, but not on the ground of delay.
no,
I am
my
not going into
my
the.
lord will give the leave to file their claims.
Yes,
Re-
but I'll
respect
do it in
only
one go.
But in respect of my instruction is that they have been paid. Now they further making claim, their further entitlement will not be entertained.
Certain that can come. You are not saying that
No,
his
it
case.
is his. It is his.
Yes, so make a recheck 1 second and come back tomorrow.
Because
All
pleadings,
the
since
learned
the
advocates
pleadings are
appearing for the
I cannot
respective
traverse
parties
beyond it.
list this matter under the same heading day after tomorrow. Day after. The affidavit in reply and the affidavit in service filed in court on behalf of the applicants be taken on record.
Because since the pleadings are complete, I cannot traverse beyond what there. Now they are coming up a new story and
No,
coming up
new
with
stories.
this.
Mrs.
No,
Doctor,
Because only the 142
what a
is
story.
My instructions are that it has been paid in
And
two
if it is
tranches.
not possible, madam, tell me, then I will allow the second application and fix this matter after vacation.
Yes, sir.
Then
Come
let
up
me
with
come
instruction.
tomorrow.
And not tomorrow, the after, please.
Day after tomorrow.
If you find that no, this first one cannot be decided, I'll place it after vacation. Second one, I'll allow.
Hello.
Let them make the claim. They are after all
Lordship,
workers.
We don't want to deprive them because we have already paid on 2 occasions to all the workers, my lord. But they are coming up with all concomitant with all those fabricated documents.
Very well.
We have to
Let me
succeed
hear
it.
Mr. Dasgupta. After 4:30, I'll not hear you. After 4:30, I'll not hear you.
Well, item number 7.
Oh, it is not. Don't
It is 4:30
don't
going
determine
on.
it.
Order. There is an order because supplementary affidavit.
Yes, my lord, I have the supplement. Very well. My lord, may that supplementary affidavit be taken on record. Item number 7. But I apologize, my lord, we couldn't reach.
You are not here.
I was coming from court 16.
What is the order? Supplementary affidavit filed in court is taken on record. Please this matter in the month list of January.
Grateful, my lord. Grateful.
Supplementary affidavit filed on behalf of the applicant. Be taken on record.
My lords, may I be permitted to mention item number 14? That's 4:30 actually.
After 4:30, no mentioning.
I'll come back next year. I'll come back next year.
Yes. Jurisdiction today. Come tomorrow.
When?
Any urgency?
No urgency.
Lordship, regarding item number 10 and 11 in today's list, can it be kept any day except for 17th or 18th?
My lord, I have an application for disclaimer, my lord, in respect of item number 10, my lord.
After vacation?
My lord, I'll
Because
leave
it
it.
cannot be heard this side, Mr. Sen.
Very well, I leave it
Madam,
entirely.
after vacation, you are there.
My application already been heard by your lordship.
All these matters after, because essentially appellate side there are so many matters. You see, I'm not been in a position to take up this matter 3:30. Every day it's being delayed.
My lord, only one indulgence, my lord. My affidavit in reply to their affidavit in opposition to my application.
So
my
don't
lord.
file it today.
Very
This is after 4:30, no file.
Very.
এগুলো সব after vacation করে দাও। কোনটা, which is your matter?
My lord, item 10.
Item
And
10
yours?
11.
11, 10 and 11 after vacation. 10 and after vacation. Just keep it after vacation. It'll be there in the same position. It'll be taken up, sir. Then you see, in the morning, there'll be no rush hour. And then your matters will be called on earlier.
My lord, would it be my lord's pleasure to pass an order to that effect, or?
No, let it remain.
Very well.
After vacation, it will be indicated in the list.
Very well, ma'am. Very.
আর লিস্টে দিয়ে দিও এবি বলে রেক্সে রেখে দিও নাকি অরিজিনাল সাইডে থাকে না এরকম বাদ দিয়ে দেওয়া হয় বাদ দিতে গেলে অর্ডার দিতে হবে অর্ডার দিয়ে দাও let this matter appear after vacation একটা অর্ডার দিয়ে দাও দুটোতেই